that Mr. D.K. Sharma and counsel.
Not DK Sharma, he cannot appear. A Talukdar.
Mr. A, okay, Mr. A. Tarugdar and Ms. A. Tarugdar and the counsel holding the brief is in bereavement. Most of matters stands adjourned today. Listing the next week.
No, not next week, after 10 days, so that.
Oh, okay, after 2 weeks then.
well.
Okay, okay. Yes,
Wait,
Hello.
I beg to mention item number 35. I'm for the contempt petition and yes. The matter has been complied with, sir. So maybe close.
upon instructions, Mr. R. Sharma and counsel for the petitioner submits that the order of this court has been complied with. So accordingly, this contempt petition stands closed, having not been passed.
May I please your lordship? So item number 39, the contempt petition order has been complied, lordship.
Okay. In item 31, in item 39, okay. Both sides are represented. This piece, upon instructions, same is the piece area. Same order. Content. Okay.
All right.
May I please, your lord.
Yes.
Lordship, I beg to mention item number 17, 17.
Yes.
Lordship, I am instructed to withdraw this petition.
Okay. All sides are duly represented. Upon instructions, Mr. R. Sharma and counsel for the petitioner seeks to withdraw this writ petition. Accordingly, this writ petition is dismissed from withdrawal.
Thank you.
Any interim order is there?
No interim order, lordship.
Yeah, please, your lordship. With the consent of the other party, I would like to mention item number 44, your lordship. In this, regarding this matter, lordship, we beg for the lordship to grant us 3 weeks time to file an affidavit, your lordship.
44.
Yes, your lordship.
It was that review petition, Your Lordship.
Huh.
On the last occasion, Finance Department was directed to file an affidavit stating the fact that they never received our communication. So they have not yet filed the affidavit.
Okay, for finance.
Thanks.
Okay. On behalf of the finance department, Ms.
RM Barua.
Counsel for the council pays for and is granted 2 weeks time to file the affidavit in this review petition. All sides are represented. Just after 2 weeks.
Your Lordship, I would like to also mention item number 15 herein. I am for the petitioner in this matter. Here, I have tried to establish contact with the petitioner. In all probability, otherwise the matter has become infructuous, but I need the written confirmation from him to withdraw the writ petition.
Okay.
So may I seek some 2 weeks time to seek
Okay.
instructions from him to withdraw?
All sides are represented. Mr. D. Boral and counsel for the petitioner pays for some time to obtain instructions as to whether or not this matter has become infructuous. Madison is adjourned today. List after
After 2 weeks. Your Lordship.
2 weeks.
Obliged, Your Lordship.
Item number 16, my lord, we require to file immediate petition, my lord. So 1 of 10 may be granted.
Okay, all sides are represented. Mr. H.R. Ahmed, and counsel for the petitioners pays for some time to file an implementing application. Mr. Madison is adjourned today, just after 2 weeks.
May I please, your lordship? Lordship, I beg to mention for listing as a motion item, my lord. My matter was last listed on 31/3, my lord. But unfortunately, I was out of station, so time was taken.
I think for motion, you have to rush to court number 3. That is the motion code. Rush to court number 3, you may still be in time.
Daily list item number 1 for admission.
Meet major lawsuit.
Yes,
Yes, list to regulation of the services of the petitioner.
yes.
In this case, my lord, petitioner is working before provincialization of the school, my lord, as grade 3, my lord. Then school was provincialized in the year 1996. In the 1996, he left out because he is the second grade gate 3 property. Then what happened? They approached before this honorable court, and this honorable court passed an order, general order, that is, before that, my lord, the service of the petitioner was approved by the government, my lord. Deputy Inspector of School, my lord, that is. One is died, my lord. Rameshwar Pine died, no? Hera. Dharma. Rameshwar Pine died.
Oh.
Now I am petitioner number 2, Manoj Dole, my lord. His appointment letter is annexure A, my lord,
Page, give me the page number.
page 24. As per resolution of the executive committee dated
No,
1990.
start from there, where you said that the service was regularized. The inspector of schools passed some order, where is that?
Oh, that part. Resolution, my lord, that is annexure 26, annexure B. Resolution number 1 and 2 adopted in the managing committee meeting Asarkata Balijan High School, Helon 3594, 51192, appointed Sri Punoram Pegu BSc, and Manoj Dole, read up to class 9 as Sokidar, are hereby provisionally approved. Then they approached before the,
But there was, if I remember it correctly,
yes,
there was High Court decision for the purpose of
provincial.
screening and provincialization. After that, this approval is before that or after that?
Before that, madam.
This is before that. Okay.
Yes, then they approached before this honorable court. In the year 2023, this honorable court has passed an order to make an inquiry before before the placing all the petitioners before the high power committee, madam.
Yes.
Then high power committee, what happened? They have made a statement that my service has not been regularized because I'm the second gate 4.
Okay.
Actually, we all are second gate 4, and accordingly, we similarly situated person have been provincialized. But I was left. Then I again approached before this honorable court to place the matter to the high power committee so that my service has been regularized, because this honorable court has already been passed to make an inquiry, my lord, before and placed all the matters to the high power committee. High power committee is still there.
Yes.
Madam, in this matter, High Power Committee has rejected the claim of the petitioner, my lord.
Where is that?
We have filed our affidavit also in paragraph 4, my lord, and in the petition also, they have annexed it. At page 80, my lord. In inviting a reference to the subject cited above, I am directed to inform you that as per judgment and order
You are reading which
in
page?
W.
You are reading which page, Mr. Sharma?
Page 80, my lord,
Get it in my petition also. That is,
in the writ petition.
yes.
80.
Yes, my lord.
Yes.
Here, my lord, the High Power Committee stated that the matter of Sri Manoj Dole of Akarata Balijan High School was placed before the committee. As per rule, there is a provision of only one post of grade 4 in a high school, and a required number of one post, that is grade 4, was sanctioned at the time of provincialization of the school. The petitioner in this case joined as third grade 4 and claimed to be dropped. Third grade 4 post. Therefore, as per norms, his name was not recommended by the High Power Committee as a drop grade 4 of the school.
Mrs. Devi, how will you get the?
My lord, this case is actually it is wrongly stated, because the gate 3, the gate 4, gate 3 who were left out at the time of provincialization. Because at the time of provincialization of the school, there is a rules, my lord, that one headmaster will be there.
But,
One-
but you see, if there is only one post, how can there can
No,
be?
at the time of provincialization, my lord, who is senior, he got the regulation, but we are left out. Then we approached before this honorable court, and this honorable court passed an order. Lordship, kindly gone through the judgment and order dated this honorable court, my lord. That is page. It starts from 47, my lord. First case, my lord.
My lord, in
All
this
the
matter,
gate 4, gate 3 teachers, all are similarly situated person. My lord, they approach before this court, and this court, after arguing, my lord, this honorable court pass an order.
my lord, in
Because
this matter,
government has made it.
in connection to WPC 639 oblique
Just
2009.
let Ms. Devi complete.
Yes.
that.
Lordship, kindly peruse 50 in the view of above, this bunch of cases will stand now disposed of with the following directions. Lordship, kindly peruse that direction.
No, you see here, from what I have understood of this order,
Yes, my lord.
is that the people who are eligible should be considered,
Yes, yes.
correct?
Hmm.
No, but if there is no post, how can eligibility be considered?
No, my lord, your lordship, kindly direction, your lordship, may I?
Does it say that you create posts and then appoint them?
No, case of the petitioner, in each case, a case will be considered in accordance with the norms, criteria, eligibility, condition prescribed by
No,
policy
I
documents.
I
Yes,
understand,
yes, my lord.
but
There is a policy decision, my lord, on basis
to
of that.
create post, where is that?
My
You
lord.
see, if only one post of grade 4 is
No,
allotted to
not
the school.
available post, my lord. After the provincialization, they approached this honorable court and they took this decision, my lord. This honorable court passed an order
I
to make
understand, there's no
it.
difficulty in reading and understanding this,
Huh.
but does it say that create posts? Posts can't be created.
No, not post, my lord. The post which is available, my lord. Posts are were available and they after
Show me a
getting this.
document that this post is available in your school.
Yes, my lord.
Where is that?
Not in my school as a whole, my lord. It may be my school, it may be in another school, my lord. Since there is an order passed by this honorable court.
Now, my lord,
No, Ms. Devi, I have some difficulty in understanding this proposition. You see, let me understand your argument.
Yes, my lord.
If I accept your statement, that means for the next 20 years, there will be no new recruitment. Every teacher or every grade 4 staff who have been left out, only they will be eligible for appointment in any post which is there available.
Yes, sir.
Is that what I should understood?
Yes,
Sent
ma'am.
from your statement?
Yes, my lord.
Then it's not possible. It will infringe Article 14.
No, sir. After this, my lord, after this order,
No,
my
but
lord,
it can't
government-
be a perennial
government-
exercise.
without the availability of the.
No, I understand. Let us say
vacancy.
there are 1,000 posts available in
Yes,
the
yes.
in the
Already
state.
more than 1,000 has been have
No, I
been
understand.
regularized.
Let
my
us
lord.
say
One
there are
or
1,000
two
posts.
is left out. That is why my humble prayer before your lordships to place the matter before the high power committee.
No, it can't be.
Since
Once
high
it is
power committee is
rejected,
still there.
it is rejected. If it is rejected, what is the point in sending it again and again? I must find, I must,
Because they
Arrive
did
at a
wrong,
finding.
my lord, because hyper committee did wrong there to reject my prayer, my lord. Because they said that I'm since gate 4, third gate 4, so they won't be able to provincialize the service of the petitioner. Whereas the similarly situated person has already been
no, please read
regularized.
this page 50, 51 and show me that if this post is not available in school X, he can be accommodated from any other school
No, the
from.
person who is working in the school, my lord, they may not get the regulation in the same school. Someone is transferred to another school and someone, it is availability of the vacancy, my lord. There is several correspondence in between government, my lord. I have annexed that that copy. my
Where is
lord.
the policy document of 13/1/2003?
Mhm. Lordship, kindly peruse annexure E page 40.
40.
Yes, my lord. The government of Assam is pleased to reconstitute the task force in partial modification of department earlier notification.
No, no, no. You see, you are making me read page 50.
50.
Page 50 starts the policy document dated 13/1/2003.
Yes, that is, I have annexed, my lord.
Where is that?
Annexure 43. Page 43, annexure
Page
F.
53.
The teacher must have put in the at least 2 years of criteria service, continuous service immediately preceding the taking over the concerned school by the government. Appointment of drop teacher must have been duly approved by the concerned district, the elementary education officer, inspector of schools. The appointment of drop teachers by the managing committee must be constitute with the enrollment of the student in the school at the time of provincialization. The school-wise norms of the numbers of sanction posts to be maintained. The provincialization particular
So
submitted
this
by the
does not say
district.
that, this does not say that somebody appointed in school A will be considered for school X. Otherwise, what would happen? I'm trying to understand your argument. Let us say in one school, there is one post of grade 4. Against one post, they appoint 100 people. Let us assume, this is only an example. They appoint 100 people. Now, 100 people will say that, well, till we are adjusted, there can be no recruitment.
No, that 100 people won't be able to appoint because it is depend on ratio of the student, my lord, actually. And that is not provincialized.
No. Please
The
don't
school
confuse
was
two
not
things.
provincialized at the time, my lord.
Devi, please don't confuse two things. I am not on the school's student ratio. What I am saying is that you say that there is one grade 4 post and you are the third grade 4, correct? Now we multiply it by 30 and now we make it 100. There are 100 persons who are appointed
No,
as grade
only
4.
they will get only the first one. The person who is immediately after provincialization
So first
of
one
the
is not,
years. First one means after provincialization, they are not provincialized. My lord, the person who came before this board, my lord, initially,
Yes,
they were not
Mr. Sharma.
provincialized, my lord.
My lord,
right.
he was a third post, my lord.
No. Third post or fourth post.
Yes.
Is it true that the regularization will cover, just tell me, this regularization process will cover whom?
So after obtain my lord, the proper procedure after selection, they will get absorbed, my lord. So selection procedure
No,
should be they
please,
follow.
please respond to what Ms. Devi is saying. Ms. Devi's argument is
Yes,
that
after provincial,
first person is already in,
yes.
correct? There
Yes,
is one
madam.
post of grade 4,
As per
one
rules,
person
as
is
per
already in,
rules,
Okay,
yes, as per
yes.
rules.
correct? Then she says that the provincialization would mean that second person who is there in serial number, their cases would be considered. Is that the scheme?
No, my lord, after first person, if the school is sanctioned in one post, then after cessation of that post, then that post will be exhausted and no second post will be created.
So therefore, if a school appoints 100 peon,
My lord, we have been
no,
regular.
please let me understand, because your argument is not so very easily acceptable.
No. We have came before this court, my lord, come before the case
No,
on the
you may come
basis
for
of
10
court
times.
order.
You may come for 10
On
times.
the basis of court order, my
Ms.
lord.
Devi, please try to understand. You may come for 10 times. That doesn't make it correct.
No, my lord, we have come on basis of court order.
You are making an
I
argument.
voted on basis of
You are
court
making
order.
an argument. I am just expanding it.
Mhm.
You are saying that there in this school there were 3 posts of grade 4. The 3 people were appointed in grade 4. School has only 1 post of grade 4. So one person has been accommodated already.
No. That school was not provincialized, my lord. At the time of provincialization, they will get only one post. At the time of provincialization, there is a rules and regulation that there are only one post will be approved or regularized. We are left. Then we come-
You are from which school? What
my
is the
lord,
name of the school?
Name of the school, my lord. Asarikata Balizana High
High
School.
school.
Yes.
Now, where is the statement that no grade 4 has been, what you call, appointed? Or their service was provincialized in this school? Where is the statement in your writ petition?
I did not mention, my lord, that statement because I have come because of on basis of court order, because I approached this honorable court on 2023. This honorable court passed an order. Then again we have come because an advertisement was
You
issued.
see, your case was rejected by the High Power Committee.
Yes, my lord.
Now you'll have to show us that in this school, you are saying that this order is wrong. Then the first statement you'll have to make is that in this school, there was no provincialization of any grade 4 post.
No, school was provincialized at the time of provincialization of that the post was provincialized at that time because one headmaster is there, 3 assistant teachers are there, 1 grade 4 is there. All these
So if one grade 4 is already provincialized, what
provincial
is
at the
the,
time of provincialized, we are not
then
provincialized
you
because
can't get it. Then you
no,
can't
no,
get it.
because
If there is no 2 posts of grade 4, we will not
no,
get
my
it.
lord, then the second post we come to approach this honorable court. We obtain the honorable court order. Honorable court order pass an order to regularize the service of the petitioner as per the policy decision, my lord. Then
Correct. You
if
see,
I am fulfill
you
the
see,
policy decision.
Today you are making a submission. I may also pass the same order. If you are found eligible, give her the post. Again, it will be rejected. You must show me that there is a post exists where you can be accommodated. If there
Then
is
my
no
lord, I
post,
need some time because I have also not.
there's only one point, only one consistent statement I'm asking you, whether a second post exists or not.
Second, my lord.
If there is no second post, you can't be accommodated.
No, my lord, the person who is already been similarly situated person, they all are second or third post. my lord.
Okay. So
And they
if-
have-
If we expand your argument, there is one chief justice in this court. I make a claim that, well, my case also should be considered. And therefore,
To be a chief justice.
huh.
No, it
So
is not
therefore,
correct.
even if
my
there is
lord.
a chief justice,
Yes, that is the
please
point. my
consider,
lord. That
please
is the
consider
point.
my case for appointment as chief justice. Can I do it?
No.
Then-
My case is not related to that, this case, my lord. It is my petitioner is
You make a,
working
you
in
show
the
us,
year
you
1994.
may have come 10 times. I am not bothered.
Huh.
My question is that is there a statement that there are one post of grade 4 which has not been provincialized, or there is no staff working there? If that is not the case, we can't create posts.
One post is already been provincialized at the time of provincialization
Then
of
you
the
can't get
school.
it. Then you can't
And
get
they
it.
were left out, my lord. That left out people come to the, and similarly situated person, all are regularized, my lord.
That's what I'm asking you. You were left out.
My lord, then I'm maybe allowed to file one affidavit to show that similarly situated person are already been
No,
regularized.
I am not bothered with that. Please don't bother me with that. I'll accept your statement that others have been provincialized.
Yes,
I'm
my
ready to
lord,
take
yes.
it.
And my
you are
post
making
is,
that
my
statement-
post has been approved by this government.
Where is it?
I have shown, and I have filed one affidavit also. Lordship kindly
Where is
peruse the affidavit in reply. Para 5.
Page?
I'm get for 2, my lord, because get for 2 has already been left out. And similarly situated person. Manoj Dole, Annexure 2.
You see negative equality, please don't show me. Doesn't help you.
No, Annexure 2.
There should be a
Lordship.
post which is existing. And you will be entitled to claim regularization only on that. If there is no post, second post sanctioned, you can't be regularized when there is no civil post existing.
But the
Yep.
post is approved, my lord, provisionally approved by the inspector school. And I have annexed one of the, Annexure
Miss
3, my
Devi,
lord.
you see, I respect you. You have
My lord, I maybe give some time
put in,
then.
you have put in so many years of practice.
Yes, my lord.
That's why I respect you. But you see, a provisional approval doesn't create a
My lord,
post.
give me next week, my lord. so
No,
that
you
I-
take not one, you can take a year, but that is what
No, my lord.
the practice.
because I could not make you understand, my lord. That's why I need some time.
Oh, I am a thick-headed person. You can't make me understand. You'll have to live with it. Thick-headed person, you can't help it.
Because I'm a second gate 4 in my school, my lord, and second gate 4 schools, the gate 4 has already been similarly situated person have been regularized as per court's order, my lord. So my humble prayer before you that my case may be
Second
placed
post, we
before
can't
the
order
high power
provincialization.
committee.
No, it can't be sent. We can't send, we can't send a matter to
Because
be
they have
adjudicated.
shown me as a gate 3, I'm a gate 2, second gate 4, my lord. I'm not third gate 4.
You see, for the 10th time, I'm asking you, does the second post exist?
So I have to take instruction.
That's why
from
I
my-
gave you an
Yes,
example.
yes,
This example, you see, please try to understand.
Yes, yes.
I am, what you call, live at this moment.
Yes.
The entire nation is
Yes,
hearing me.
yes, yes.
I'm asking you a question again. There is already a honorable Chief Justice in this court. Can I say that please consider me, my case be considered and
But your
my
lordship
case
has
be
already
considered?
been regularized, my lord. Your
No, no.
lordship has already been, but
No,
in my
no.
case, my lord, the petitioner is not regular at the time of appointment. They were working as a non-provincialized school, my lord.
I'll make that.
Depends.
No, I need some
query
more
of
time, madam.
the query of the court. No, from the submissions made by Ms. K. Devi and counsel for the petitioner. It is projected that the petitioner is the second
Grade 4.
grade 4.
My lord, as per High Power
Employee-
Committee report, it is third grade 4.
No, it's
No,
okay.
no, second grade
I am
4.
writing her statement.
Yes, yes.
She is the second grade 4 employee in which school?
School, my lord.
Acharya
Tarakata,
AC
Tarakata, Balijan.
ACHERAKATA, Balijana, BALIJANA High School. And it is projected that the Hyper Committee had wrongly considered her candidature to be a third grade
grade
3
four.
post. Full stop. Be that as it may, the query of the court is whether a second grade 4 post exists in that Acharya Balijana High School. On the said query of the court, it is submitted by the learned counsel for the petitioner that there was one post which has been regularized
At the time of provincialization.
at the time of
That's good.
provincialization, and that there is a second post which
It's
was
left out.
provisionally approved by the inspector of schools. Full stop. There is no material on record that the provisional approval by the inspector of schools has resulted in creation of a second grade 4 post in this concerned school. Full stop. Under such circumstances, it is submitted that the purpose of approaching the court is that the candidature of the petitioner be recommended for, be placed before the High Power
High Power
Committee to be considered for regularization in the second
Grade 4.
grade 4 post. Full stop. Accordingly, the query of the court is that if second grade 4 post has not been created with appropriate approval from the finance department, can the court issue a direction to the respondent authorities to reconsider the claim of the petitioner? First of all, on such query, the learned counsel for the petitioner raised for some time to address the court. Matter stands adjourned today, list after 2 weeks. But Ms. Devi, Next time also, please remember thick
Yes,
head,
yes, my lord. I will
thick head.
make it.
Yes, Mr. Goswami.
Last order Lokship Chandni Perus like.
Yes, I have seen that. Yes,
My lord, affidavits are being filed in 5 matters today, my lord. There was a delay in getting the affidavits from the department, getting the information.
no,
We
but,
are filing
no, but in the end,
my lord,
what you call, what is the, what you call the, there was a second deduction again. On that, we are not basically on the, insisting on the affidavit right now. You
My
see,
lord.
his case is that his money was sanctioned,
yes,
tax was deducted.
yes.
Again, when you pay, again tax is deducted. That is the only thing he's asking.
Lordship will give me just 5 minutes, my lord. I'll have the.
Okay, second half, we'll give you
Second
more than that.
Yes,
Because the only, you see, the only difficulty is with the amount being so small,
yes,
making the petitioner wait for 7 years is actually too much. The case of the Mr. Goswami is only very simple. That certain amount was, he was entitled to get payment. While calculating that, tax amount was already, the professional tax GIS and GPF were already deducted.
deducted, yes.
And he was entitled to X amount of money.
Yes, my lord.
When this X money came to his account, his passbook shows again there is a deduction. Supposing he was entitled to 7 lakh rupees, in his passbook 6 lakh was entered.
Yes,
So then he found out that the GPF, GIS and tax was again deducted.
I'll just.
Correct.
Lordship will have it in the second half.
Correct. I have understood that correctly.
I was the original counsel, that is why I am appearing in this case, Lokship. I am the original counsel in the original case. In
No,
this-
I understand that. I understand that. No, but it is, at times it is good to give some pro bono service.
Item number 3,
Education আছে But in this case, they have rejected the
Oh, Mr.
hyper committee.
Sharma, you are there behind. I will,
Kushal Chandra Bora to do it.
I will send across to you one order for your perusal. Just
Thank you.
look at it. I think by evening I'll get it out and I'll send it to you. Yes,
My lord, they have their name placed before this hyper committee, but hyper committee rejected their name, my lord, because some documents have been manipulated. My lord, let them bring instruction, my lord, a record, my lord. What type of manipulation I don't know. My lord, let your lordship can kindly be passed an order to bring the record, my lord. Because they have rejected our cases, not provincialization because of that. No?
no, you see, it's very simple in their affidavit in opposition if you come.
Yes,
Paragraph
yes.
6 says that your name was not there. So the record will not improve anything.
Free the deputy inspector school as per report headmaster.
Because you see, negative can't be proved. You have to show that your name exists in that school and there are
No,
records.
they have the lordship kindly peruse the page 85. Because in affidavit they have stated something and in hyper committee they have stated something, my lord. That's one. I would like to reply, my lord, actually, in this case.
No,
Because-
what is the name of the petitioner?
Petitioner's name is lordships. Kusum Chandra Bora.
Kusum Chandra Bora.
Yes, my lord, that Kusum Chandra Bora is a lord.
So your reply says that
Yes, my lord,
this
that-
has been manipulated. Now,
Yes,
where is,
Kusum
where is,
Chandra
where
Bora, 85.
where
page
is that
85.
resolution? Where is that resolution?
My lord, matter of Kusum Chandra Bora
Where is that resolution? Where is the
resolution.
copy of the resolution?
দিগদাৰ নহয়, বৰ দিগদাৰ। Resolution 16, page 16, second
No,
resolution,
no, page 44.
page 44.
If I have understood it correctly, it is page 44.
In Assamese version, my lord.
Yes.
But I have translated copy, my lord. That is why I say,
No, if they are saying that it is a manipulated document, it should be Assamese.
no. My lord, in the HIPAA committee, they have stated that they have rejected because committee resolution was, managing committee resolution was manipulated. But in affidavit, they stated that their name is not shown. And my lord, in resolution number second, that is page 16, today's meeting take resolution that unemployed youth Sri Kusum Chandra Bora, who has been working as a director from 1981, who trained by the establishment, has been working in the school since 1989 as an honorary teacher and help in the teaching. He should be appointed as assistant teacher in the school, my lord. And in Assamese version also, lordship page 31. 31 in Assamese version, my lord. Appointment. Or English translated copy is 30. The students are increasing day by day in Bari primary school, and the two teachers faces many difficulties due to this. The managing committee of dated 9/7/89, the school appointed well qualified Kusum Bora on 10/7/89 as assistant teacher in the school, and this appointment letter is given. It is also mentioned that have to work an honorary till the day post is not regularized by the government and have to participate in all works. Appointment letter was given to you. And his name is third, my lord, Kusum Chandra Bora, page 44 in Assamese, that is inspection report.
Just on.
His name is shown as 3, Kusum Chandra Bora.
Just on. Yes, your reasons are different. You'll have to produce the records then.
Yes, my lord, para 5.
Okay.
Dear affidavit.
Ms. K. Devi, counsel for the petitioner. Petitioners. Has referred to
Next to Amanda.
minutes dated 16/2/2016 of the High Power Committee. And she has referred to consideration of assistant teacher at Ghahibari, GHAHIBARI LP School in respect of petitioner number 1, Kusum Chandra Bora, KUSUM Chandra Bora,
Second one is my lord. Suraj Kumar Tide,
Then comma, number one,
number one.
Gao Budha Chuk, GAO BURHA CHUK LP School. In respect of Suraj SURAJ Kumar Taid TAID. And Palash Bari PALASH BARI LP School. In
And
respect of,
Ratul Bharali. 11.
oh no, sorry, no, it is 11, Karang Balijan, KARANG Balijan BALIJN LP School. In respect of Ratul Bharali.
Petition number
This
3.
is page 85. Wherein against the three petitioners, the notice to the effect that the managing committee resolution was manipulated. Whereas in paragraph 6,
Paragraph 5, my lord. Paragraph 5. The petitioner, there are no record available in their office regarding submission of the proposal. 5, my lord.
no, 6,
6 also.
paragraph 6 of the affidavit. As per report of the Deputy Inspector of Schools, Dhokwa Khana, and Block Elementary Education Officer, Bordoloni DORDOLONI,
Mr. Muribo,
Ghiramara,
8 of city.
and as per report submitted by the headmasters of the
Yes.
said 3 schools, there is no teacher in the name of the petitioners. Accordingly, the elementary education officer, the elementary education department shall take note of the stand taken in paragraph 5 and 6 of their affidavit in opposition, and the entries made in the minutes dated 16 to 2016 of the High Power Committee, and produce all the relevant records pertaining to these 3 petitioners. Next, for the Learned Standing, Mr. A. Fukan, Learned Standing Counsel for the Elementary Education Department, shall send a downloaded copy of this order to the competent authority to ensure production of records on the next date. Will be 4 weeks time.
4 weeks.
Please start for 4 weeks.
Or and in this case, they have filed affidavits, my lord. And they have rejected my pair. Hyper committee has been rejected because detailed particular and the inspection report in respect of the school submitted at the time of provincial are not available. But they have filed affidavit.
Yes,
My lord. Here,
no, Ms. David, you have to start your argument.
Yes, my lord. This case is similar, like drop teacher, my lord.
Yes.
And at the time when he was appearing, the headmaster won't be able to submit the documents, my lord. That is why they have stated that. Your lordship kindly peruse the affidavit, my lord.
I have read that.
Affidavit filed by the respondent, my lord.
Yes, I have read that.
Yes, my lord. So my humble submission before your lawsuit to place the matter before the HAPA committee so that they can inquire the matter and.
No, there's another stand taken. He said that if your arithmetic is correct, then when you joined school, you were 17 years.
17 years.
Age also disputed.
I have no knowledge regarding this. I have to ask my client.
In my,
If
my
it
lord,
is there, then if it is,
in my
true,
lord,
then I
another
would like to
case.
do this petition.
No, I was just telling you because you said that when I should read that affidavit, that's what I'm saying. I've read the affidavit and affidavit says that your arithmetic makes you 17 years when you join service.
Oh.
So.
Then
you-
I have to ask my
Okay.
client madam, regarding this point.
In my lord, another case 2575/2013 writ petition. Here petitioner is same Onukul Chandra Nath. Here age was stated as 48 years, my lord. In
Is it?
2013. This is
16.
13
yes, April 2013.
at page.
Age was no, my lord. I am not annexed it, my lord.
Acha, acha.
Yes,
You have a copy of that? You
Yes,
show,
ma'am.
show that to me.
হ'ব পাৰে। গম নাপাওঁ।
WBC.
যাব আৰু কিছু হয় নহয় যদি ভুলকে এইটো ফৰ্টি ইয়াৰ্ছ চলে 16ত কিমান বয়স হ'ব যাবা ওলাচোন
In view of the stand taken in the affidavit in opposition filed by the Elementary Education Department.
Secondary Education Department.
Secondary Education Department to the effect that if the statement made by the petitioner is accepted, then the petitioner would have joined service when he was 17 years of age.
It's not that.
The learned counsel, Mr. U. Sharma and his standing counsel for the Secondary Education Department has submitted that as per records available with the department, the petitioner had approached this court earlier in point of time by filing WBC 2575 of 2013, where he is projected his age to be 48 years in April 2013.
13 তাহা নাই নেকি
But contrary to the previous affidavit, in the affidavit filed in support of this writ petition, the petitioner has claimed his age to be 40 years. As on 15/11/2016. Therefore, the court is inclined to put the petitioner to notice as to why, for making a false statement, his writ petitions should not be dismissed in limine. The learned counsel for the petitioner, grace for is granted 2 weeks' time to respond.
My lord, that case I had no idea. I was not advocate.
No, that is why I am not saying anything to you.
Yes.
I am making a
If it is
remark
wrong,
against
my
the
lord, I
petitioner.
would like to withdraw this petition.
I have given the remark in the petitioner.
The number 2 dear mode.
Mhm.
Yes, on number 2 like
I have given my order.
Yes.
You find it in my order.
I'll give my.
Item number 5. Item number 5.
Mr. Sharma. Here, nobody is appearing. But the issue is that the tenure of the SMTC is 5 years,
Yes.
which is expired by now. So we wanted to get you to get instructions as to whether the tenure of the previous SMTC has expired or not. That is the only thing we require. I think this has become infectious. This is that Mr. Mazumdar is here, no?
One minute office memorandum also there.
No, we are aware of that. That is why we posed that question to you.
Yes.
The petitioner is not appearing. The tenure of the SMDC is 5 years. It appears from this repetition that the term is expired.
Yes.
We just find out by 2 o'clock as to whether it has expired or not.
In 5 years. 5 years.
Because you see, this repetition is of 2017. So
Already
17
5
and now it is 23. So it is definitely expired.
expired. Yes.
So just go through it, and if it is expired, you have the copy of the repetition. You take this copy. If it is there, just tell us. We'll dismiss the petition.
6.
Yes, Mr.
May it please
Manan.
your lordship. This matter, the petitioner was for the post of the teacher appointment as subject teacher of Samota High School, your lordship. Here, your lordship, the issue is that she was selected, but she was not appointed.
What is this order? Last order, I could not follow it. It says, well, the context I am not following it.
Yes.
Mr. Y.S. Manan, learned counsel for the petitioner, prays for 2 weeks' time to file public advertisement put up by the authorities leading to selection of the petitioner for subject teacher chemistry in Samata
Yes.
Higher Secondary
Higher
School.
Secondary
What is this? In what context this is?
No, that part even I am not sure because that
Okay.
is the I did not pray for any.
I don't know. Let's just see that.
No, just a moment, because I also am not very sure, because I have never made such prayer. The matter relates to advertisement of a post of teacher, subject teacher in Samota School.
I think the court then wanted to you to produce that advertisement. Perhaps that is the
Advertisement, I think,
intent.
yes.
Since I don't know the context, I
Yeah, let me.
not-
Or to produce the public advertisement. It was actually to put up the authorities leading to this.
some type.
File the public advertisement. The public advertisement, actually, I did not have the copy of the advertisement. I said I will produce a copy if required. So court has recorded it that way, that I'll file it.
Okay.
Anyway, but the question is not of the advertisement. It was a subsequent, that was in the earlier case. Subsequently, there was a direction. Subsequently, there was a direction by the Honorable Court. We can proceed from there, Your Lordship. That court has already considered everything and directed the authorities to consider the prayer. And after consideration, we have come in this case. So, if Your Lordship will kindly take up the order of this Honorable Court. That your lordship will find at page 36. I'm not reading the first part. Everything has been recorded in this order, your lordship. Page 36. Lordship has got that. Page 36.
Page
36.
32,
36.
36.
I'll just read this. Everything is specifically stated in this order. Second para, the grievance expressed by Mr. Manan is that despite the recommendation made by the Inspector of Schools Nalbari by letter dated 19/9/2015 to the Director of Secondary Education Assam recommending appointment of a petitioner as subject teacher in chemistry in Somota High Secondary School, no action has been taken on the said recommendation, and the limited prayer made by Manan is for a direction to the Director of Secondary Education Assam to consider and take appropriate decision on the said recommendation, bearing in mind the fact that the validity of the select list is expiring on 30/11/2015. He has submitted that a perusal of the letter dated so and so would go to show that the school is suffering a lot because of non-availability of the subject teacher in chemistry. Mr. So and so does not have any objection in issuing a direction to the Director Secondary Education to consider this and take a decision on the recommendation of the Inspector of Schools Nalbari conveyed by letter dated so and so. Perusal of the letter dated so and so goes to show that there are anomalies in the B.Ed certificate of the serial number 1 of the select list, and the candidate at serial number 2 had given a no objection certificate for appointment of any other person in Samata HS school. It is also reflected that the petitioner is at serial number C of the said list. Having regard to the submission of the learned counsel for the parties and the order proposed to be passed, I do not consider it necessary to issue notice on so and so. Without expressing any opinion on the merit of the recommendation, this writ petition is disposed of with a direction to the Director of Secondary Education Assam to consider and take a decision on the letter of recommendation dated so and so within a period of 3 weeks from the date of receipt of the certified copy of the order, and the validity of the list would expire on 30/11/2015. So basically, after that, they did not do anything. We filed a contempt petition that is pending, but it has become infructuous because subsequently they have taken a decision, and against this decision, we have come. That your lordship will find at page 39.
Yes.
After the contempt petition was filed, this order was passed by the director. Seen order dated so and so from the Inspector of School Nalbari pursuant to the approval of the post in chemistry of Samota. The following candidates secured the first position. I am at serial number 3, your lordship, in this case. So the principal list is signed by principal. There is no signature of inspector. The case is not recommended by the District Approval Board as provided in Rules 2003. The report of inspector is silent as to whether the initial select list was prepared. The Inspector of School is directed to place the matter in the District Level Approval Board and submit a report whether the post was approved or advertised after so and so. So this was issued by the director. Now, your lordship, the impugn order is at the next page. Page 40. Peruse the record and order dated so and so in WPC number so and so. The briefcase of the government is the Secondary Education Department. Approved 507 posts so and so in provincialized schools, out of which 22 posts were allotted to the Nalbari district, which are to be filled up as per the Assam Secondary Education so and so rules as amended in 2012. One post of the postgraduate teacher in chemistry in Samanta school was approved for the appointment. The District Approval Committee of Nalbari district forwarded the name of Rumi Kolita for appointment as postgraduate teacher against the post of chemistry in Samota High Secondary. But although she stood first in the select list, she was not appointed for anomaly in the B.Ed certificate. Sayeda Wahida Parveen was in the second position. She participated in the interview in other schools and got appointment in other schools. Although the name of the writ petitioner stood third position in the said list, but her name was not recommended by the District Approval Committee at the relevant time when the process was undertaken. On the prayer of so and so, the Inspector of School so and so submitted letter dated 19/9/2015. This is the letter recommending her name. The proposal dated 19/9 so and so of the Inspector of School is a belated proposal and not submitted as per Rule 7(5) of the Assam Secondary Provincial Service Rule 2003 as amended in 2012. Requires the school selection committee to forward the select list to the Inspector of Schools to be placed in the District Approval Committee constituted under Rule 8(5) of the said rules. The District Approval Committee shall prepare a select list equal to the number of vacant posts on the basis of the marks secured by each candidate. The letter dated so and so of the Inspector Nalbari is simply a letter with assessment sheet signed by the principal in charge, Samata High Secondary School. And the same is also not duly signed by the chairman and member of the board. There is no minutes, no approval of the district approval committee. As such, the letter dated so and so cannot be acted upon since it is not submitted as per the provision of office memorandum number so and so, as well as the rule 7 of these secondary rules. Therefore, Jinatra Islam cannot be appointed to post of postgraduate teacher in chemistry in Samata High Secondary School, Nalbari, on the basis of the proposal received from the inspector of school. Further, the approval accorded during 2014-15 for appointment of postgraduate teachers already expired on 31/3/2016. I'll come to that. And thereafter, Finance Department has also not extended the validity of such approval. However, it is pertinent to mention that after receiving the letter dated so and so from the Inspector of Schools NDC Nalbari, this office order issued under memo number directed the Inspector of Schools NDC to place the matter in the district approval committee Nalbari for recommendation and thereafter submit a report. But till date, no such approval as well as report received from the Inspector of School NDC Nalbari. In view of the above circumstances, the case of the recommendation of petitioner cannot be acted upon. So, what the ultimately directed has stated that he has placed the order, directed the Inspector of School to place the matter before the committee, district committee. Thereafter, submit the report. That was not done as per him. It was done or not done, it was not placed before it. Therefore, I am not concerned. So that cannot be a ground. The ground should have been that, yes, the committee has considered and have found me not eligible or whatever. Then he might have rejected, or if the committee has approved my name, he should have given some order that because of this reason, you cannot be selected. Fine. But here the issue was that what has happened before the district committee, whether they have taken a decision, not a decision, which was not placed before the director, I cannot do anything. It is the director who should have sent a reminder. Replace it.
The approval is expired.
That cannot expire. Why I am saying that? There are decisions I'll mention those. Earlier I have mentioned there are decisions which says that during the pendency of a case, in a pendency, during the pendency, if the select list expires, it cannot be the ground for not appointing. If there is no case pending or after the expired select list I would have come, then it would have been a separate issue. The division bench judgment of this honorable court on the basis of a Supreme Court judgment, the court has in 2003 ZLR 691. I'll give a copy of that. The court has specifically stated that it cannot be. 2003 ZLR 691. Para 3. Because that is the moot point I think your lordship is looking into. This is Muhammad Maidul Islam and others versus State of Assam. This is by a division bench. Here I'll be reading para 3. Lordship has got that.
Yes, yes.
In para 3, your lordship will kindly pick up. In the state of so-and-so, 2003 SCC 69, while considering the aspect of life of a select list, the apex court said that merely because a period of 1 year has elapsed during the pendency of litigation, it cannot be said that the court could not exercise the power and issue direction in regard to the select list which has expired its life during pendency of the court proceedings. The decision cited by the learned single judge for the purpose of saying, once the validity of a select list has expired, it cannot be given operation on its reading does not apply in the facts of the present case, as in those cases the government taken a policy decision not to act on the select list, and accordingly, the select list was not operated, and consequent thereof, the court has declined to give relief. Non-giving the relief is not the basis of the select list being expired during the pendency of the proceeding. In the present case, the admitted fact emerged clearly indicates that although the petitioner's name were included in the select list, they have not been given appointment, and the life of the select list expired during the pendency of the proceedings before this court. No cogent reason for not operating the select list has been given by the government. Under these circumstances, we set aside the order passed by the learned single judge and direct the state government to take up the exercise for giving appointment to the petitioner appellants therein in accordance with the select list prepared on so and so, if no policy decision contrary to the offer of the select list is taken by the government. Here there is no order of the select list or that the appointment with that post has been cancelled. That is not taken. So till the order was passed by this by the director, they have not taken any decision not to appoint from the select list. So that second judgment, your lordship, that I will refer. Again, another judgment of here, your lordship, many judgments are there. I am just referring to two or three judgments. 2011, 2 GLT 510. Here I'll take up only one paragraph, paragraph 26. Here also,
Is there a provision in these rules for the validity of?
validity is
selected?
1 year. There are directions from the Honorable Supreme Court also that normally the validity should be a period of 1 year.
No.
Even if it is not there in the rules.
No, is there a specific rule in this?
In this
2003 rules?
In the 2003 rules, there is 1 year. 1 year.
1 year. It is,
So it's
which prescription is there?
Even if it is not stated, then also it should be taken as 1 year because of the fact that there's a direction by the Honorable Court in a, I don't remember that case, but
Okay.
it's a long, old case where it has been stated that normally a list should be in 1. Even in this decision,
Yes, it is there.
it is there.
Uh,
Even if it is not there, then also the court has stated it should be 1. So that is one point, your lordship, first point. On the same ground, I have another matter, another case. The second judgment, your
Case number
lordship, kindly-
372. The validity of select list shall not be exceed beyond
Let
1
me
year from the date
point
of
out the
its
second judgment. your
publication by the director.
lordship. 2011 to GLT 510. 2011 to
Just a
GLT
moment.
510. I'll just read the paragraph. That's it. One paragraph.
Just. Yes,
Paragraph 26. Only one paragraph here.
yes.
In this case, even this judgment was referred 2003 3 GLR and some other judgments. I'll just refer to that. In this court in Lodebam Imbal Devi, State of Manipur 2003 GLT. So Khovendra Singh versus State of Assam 2001 2 GLT. Akoijam Dorendra Singh and other state Manipur so and so GLT, and Honorable Apex Court in the state of UP versus Ram Saroj, that is already reflected on the considering this, has held that the claim of a candidate included in a panel cannot be defeated merely because the currency of the panel expired during the pendency of the litigations when there are vacancies available for making appointment. The Apex Court is of the similar view in Vijay Kumar Sharma and others versus Chairman, School Service Commission and others, 2001 for SCC. That there cannot be a denial of appointment to the selected candidates merely on the ground the currency of the panel list expired when the vacancies are still existing. So these two facts are there. Then, your lordship, in the case of all these cases, your lordship, on the same point. So I am not giving all the cases. Just making the paragraph 26 contains all these cases in that case. Now, your lordship, there's a third judgment, which is exactly the same with this case. There's a Supreme Court judgment that is, your lordship will find 2013 11 SCC 737. This I will have to read a few paragraphs here. 737, 2013, 11 SCC 737. Here only difference is the select list was that here it is the waiting list. That is the only difference, except that the facts are also similar to this case. That's why I would like to read the facts also. For paragraph 1 to 7, I'll just read the facts. If your lordship has got the judgment, yes. The leave granted, the Public Works Department of the, if your lordship has just grant me, I'll read these 7 paragraphs. The Public Works Department of the state of Jammu and Kashmir conducted the process of selection for recruitment against the post of junior engineer. Satpal, the respondent herein, participated in the said aforesaid selection process. He was successful in as much as he figured in the final merit list, select list of the scheduled caste candidates prepared at the culmination of the selection process. Having learned that some scheduled caste candidates above him in the merit select list had not joined, in spite of having been offered appointment, Satpal addressed a representation to the appellant seeking appointment against the available vacancy. In his representation, he mentioned the name of Triloknath as one of the selected candidates who has been offered appointment but had not joined. In his representation, he has pointed out that in the merit select list pertaining to the scheduled caste candidates, his name figured immediately after the name of the Triloknath. So here also the same thing, because the first two candidates, first candidate was not eligible, second was provided, she has given NOC that she is not joining some other school, so I came with the next. Now your lordship will take para 3. Since the representation filed by the respondent remained undecided, he approached the Honorable High Court of Jammu and Kashmir, hereinafter referred to High Court, so and so. Before High Court, the respondent Satpal reiterated the factual position asserted by him in his representation. To substantiate his assertion pertaining to Triloknath, that although the aforesaid Triloknath has been offered appointment against the post, Triloknath had not joined against the same. He placed before the High Court a communication so and so issued by the chief engineer so and so was not interested to join against the post of junior. Before the High Court, the respondent relied upon the prevalent rule whereunder a waiting list was valid for 1 year. The fact that the prevalent rule envisages that the merit list of candidates in a continuation of those offered appointment would constitute the waiting list and would be valid for a period of 1 year was not disputed even before us. Same thing here. 5. Despite the High Court having issued notice to the state government and had required it to file pleadings, the state government appellant before this court did not file any objections. The right of the appellants to file objection was closed by an order dated so and so. In the aforesaid view of the matter, it was natural for the High Court to infer that the assertions made by the respondent before it were truthful and acceptable for the final determination of the controversy. Despite the aforesaid, the High Court disposed of the aforesaid writ petition in the admission stage by directing the appointing authority to examine the claim of the respondent for appointment against the post of junior engineer so and so, by keeping in mind the communication dated so and so issued by the chief engineer affirming that Triloknath was offered appointment against the post under reference has declined to join. The High Court required the appellant herein to take a final decision in respect of the appointment of the respondent within a period of 2 months from the date of copy of the order of the High Court was made available. Exactly the same thing here, your lordship. On the motion stage, they were directed to consider my appointment on the basis of the letter. Here, this letter, mine is 19.5. So after that, what has happened, your lordship? In compliance with the direction issued by the High Court by the order dated so and so, the appellant passed an order on so and so. By the said order, the claim of the respondent for appointment against the post of junior engineer was rejected on the following reasons. Now the reasons are very same to it. In view of the fact the waiting list issued in respect of recruitment has outlived its validity way back in 2008 itself, he cannot be granted appointment in accordance with the same, and that the above reasons vacancy cannot be filled at a belated stage. So these are the 2 reasons which are basically the same reason which has been taken here, that the list has expired, now you cannot appoint. Agree by the rejection order dated so and so, rather than assailing the same by way of a fresh writ petition, which I am doing, the respondent filed a contempt petition. The aforesaid contempt petition was disposed of by the High Court by the order dated with the following observations. This is like an observation in a writ petition. That's why I'm reading. The claim of the petitioner for his appointment as junior engineer during the validity of the select list, the duty was cast upon the competent authority who was seized of the select list, wait list, to fill up the vacancies from the wait list. but it failed to perform its duty. It is not the fault of the petitioner that his claim for appointment was not considered during the validity of the select list, wait list. The fault is committed by the authority, and the petitioner cannot be penalized for the same. The claim of the petitioner on marriage deserved to be allowed for being appointed to the post of junior engineer grade 2 so-and-so wait list was in operation. Same having not been done despite requests having been made, his right of consideration for being appointed would thus survive through such claim as considered by the government after expiry of the validity period of select list wait list. Consideration order issued by the government does not comply with the court directions. Before initiating action for framing rule in this contempt petition, it will be appropriate to afford an opportunity to the respondents to consider the whole issue and pass orders in accordance with the judgment of the court. 4 weeks time is granted to the respondent to reconsider the whole issue in the line of the observations made herein above and file compliance before it the next day. Then the authorities came before the Honorable Supreme Court, and the Supreme Court in para 17. Kindly take up para 17. Rest are your lordship other decisions. I'm not reading those. It gives us no pleasure to record that the state is not an adversary and ought not to have behaved in the manner it has chosen in the facts and circumstances of this case. It is the first instance it failed to even file a response before the High Court to the writ petition preferred by the respondent Satpal. The matter could have been adjudicated on merits had the High Court chosen to do so. In order to ensure that justice to the respondent was not delayed, the High Court considered it just and appropriate to direct the appointing authority to consider the claim of the respondent consequent upon Triloknath having declined to join the post of junior engineer civil, mainly because the respondent Satpal has approached the High Court for relief. The appellant rejected his claim on only unreasonable grounds. Rather than focusing on the merits of the claim raised by the respondent Satpal, the appellant chose to initiate proceedings which would deviate the legal process from the merits of the claim of the respondent. Had we issued notice to the respondent Satpal based on the technical pleas raised by the appellants, the respondent Satpal may not even have been in a position to defend himself before this court. Litigation before the court is an expensive proposition. A poor scheduled caste candidate cannot be subjected to unnecessary harassment at the hands of the mighty state. It is for the aforesaid reason that the instant order is being passed for doing complete justice in the instant cause. In view of the factual and legal positions discussed by us herein above, we are of the view that in the facts and circumstances of the case, it was just and appropriate to direct the appellants to appoint the respondent so-and-so in the post of so-and-so. The aforesaid appointment will relate back to the permissible date contemplated under the rules laying down conditions of service of the cadre to which the respondent Satpal will be appointed. Naturally, the respondent will be entitled to seniority immediately below those who have been appointed, the same process of selection. Here, the seniority is not a question because it's the single post as of here. Now, the question is, you have appointed a person, the first one and the second one. Since the first one was not eligible, it was rejected. Second one has refused to join because she has already joined in another school. So it is not a fact that they do not want to appoint any person in that post. If that ground has not been taken, and that is not a ground also because they have on their actions, it is shown that they want to appoint. Now the third candidate should have been appointed. Now they have decided that the process has not been correctly taken. If the process has not been correctly taken, it was the duty of given by this Honorable Court directing them to finally decide on consider the matter and decide. It is the court has not given them that you reject it on a whimsical ground. The rejection should be on the merit of the case. The merit has not been taken into consideration. It has said that the validity of the list has expired. This process, which was supposed to have been done, have not been provided to the director. Whether they have done it or not, it is the director, his own officers, he should have asked them why you have not placed the required report before me. That should have been the just because a report is not placed by the district committee, you reject my appointment. What kind of an order is that? So that order cannot survive, your lordship, under Article 226, and it has to go. Appointment giving me or not giving me is a consideration they should have made on merit of it. My case. It's not on the basis of the fact that since because of the order, the report has not been placed before the director is unable to take a decision and therefore my selection is rejected. What kind of an order is that? The 1 year period or validity period is a part which has already been decided by the Honorable Supreme Court as well as this court, that it cannot be a ground when you have challenged it within time. Second part is that if the post is not required, that is required because they have already given appointment to another person. So the post is a requirement. So these two factors are in consonance with law. Now, third factor as best would be you consider my case for appointment and on the merit. Now you cannot reject me just because the particular report has not been placed before the director. This director should have given a reminder, you replace it before. Or I'll pass an order, adverse order against you. And for the lapse on the part of the authorities, why should I suffer? That's my case.
Yes, Mr. Sharma.
My lord, in this matter, we have filed our affidavit, my lord. Here, my lord, in the point number 6 and last three line from the bottom. It is pertinent to mention herein that the petitioner name enlisted as third in the said panel list, yet her name was not recommended by the district approval committee at the relevant point of time. Hence, the petitioner could not be appointed as postgraduate teacher in chemistry in Samata Higher Secondary School. And the next point, that the deponent begs to
Just
state-
a moment.
yes. So
No, but it appears Mr. Manan is right. You see, there is a, it's not in dispute that there is a panel.
yes, panel.
And you give the offer to one, he refuses, two, you give, he refuses, three is available.
Yes.
But you say that the recommendation was not made. But then why you have a panel? Why you have to make a recommendation for everyone?
List of
In fact, your lordship, the honorable court in the earlier round has directed them to consider on the basis of the report of the inspector of schools, the letter. So they should have, on the basis whether panel is there or not, it goes, because once the court parts an order directing them to consider on the basis of that letter, they consider it. If they want a report, that report should have been called for, fine, you call for the report. Now the report was not placed before the director. For that, you reject my candidature. That is where they have gone wrong. That is my case.
My lord, page 372 of Assam Secondary Education Provincialization Service Rules 2003.
Yes.
Requirement of 14. So, number 6, my lord. After receipt of the panel under sub rule 5, the district approval committee shall prepare a select list equal to the number of vacant posts on the basis of the marks secured by each candidate and a manner as provided in Schedule 1. The select list so prepared by the district approval committee shall be submitted to the director who shall approve the select list submitted by the district approval committee and publish the list on the official notice board in such other places as the director may consider fit or proper. Well, after approval of the publication of the select list
No,
under
please read this number 6 again. After receipt of the panel,
yes,
under sub-rule 5, the district approval committee shall prepare a list equal to the number of vacant posts.
yes, my lord.
Now, suppose in chemistry, you are in chemistry. In chemistry, there is one post.
Yeah, one.
So he will give an approval for only one post,
Yes,
one person.
yes.
Then why there is a panel?
No, in fact, they have published the selection of one person for appointment, but ultimately it was rejected because she does not have the
I
VAT.
understand. My question is, there is a panel.
Now, there is a panel, obviously there will have to be a panel. From the panel, they have selected the first
So,
person for
every
appointment.
time, let us say there is a panel of 10 people.
Yes.
In Siritum, everybody starts rejecting.
Yes.
One rejected, two rejected, three rejected. So therefore, does this rule 6 mean
Hmm.
that every time there, the authorities will meet again, have an approval made and then send?
There is nothing like that in the rules. It has not
No,
stated.
rule 6, what Mr. Sharma is showing.
But
Read rule 6.
the rule 6 in fact says that there has to be the panel, from the panel, if there is one post, that post has to be provided for appointment. So that post was provided for appointment. There is one post, one
No,
person
this
has to
would
be
also
recommended.
mean that it would also mean-
Recommendation for one person, not 3 persons or 4 persons.
And my
Even if
lord,
there is one person.
and panel list
No,
is
no, no, no.
prepared
Here it
from
says-
amongst the
Here it says,
eligible
after receipt of
candidates.
panel,
Yes.
so and so,
Yes,
approval committee shall prepare a select list equal to the number of vacant posts.
yes, that is where it is. The panel is prepared.
No, no, so therefore only one recommendation.
Then there will be
One-
one recommendation.
If one recommendation.
One
is-
goes,
No, no, if one goes, then the panel fails.
then the second comes.
That
So, my
means
lord, first
again, there will be an approval.
But that is not stated there.
No.
Well,
You-
oh, maybe,
since
maybe,
this-
yes.
every
Even
time
if it
has to
is
be
correct,
yeah,
then again they will go for approval. If the second goes, then they go for approval for third goes, then for fourth, fifth, whatever it is. So it will be every time they will give an approval. I have nothing to say on that. Let them give 10 approvals, no problem. But question is whether they will do it on the basis of this honorable court's direction, whether they have done it or not. They have not done it because they have not produced that approval before the director. That is why I am rejected. They should have produced the list before it, because the direction by this honorable court was very specific that you should act on the order of the inspector of schools and pass appropriate order. The director issued a letter to the inspector of schools saying that you place the matter before the district committee and get the approval from the committee. He placed, he did not place. I cannot look into that. It is the director who will have to ask him whether he have placed or not. If you have placed, produce the report. If you have not placed, don't say whatever you have to do within this period. This is his direction. The IS have not done anything there because of that, or he has done it, I don't know. Nobody knows whether it was placed, it was not. Even in the affidavit, they have not stated anything. Now, why my appointment has not been given? On the basis that it is not placed before the director. The last line specifically indicates your appointment cannot be considered because it is not placed before the director.
let Mr. Sharma
Yes.
complete.
He have to explain that.
Here, my lord, first candidate is Rumi Kolita, my lord. So Rumi Kolita, my lord, not appointed due to her anomaly in B.Ed qualification. So my lord, as the Rumi Kolita is first candidate, so my lord, panel list is over. Selection is over, and my lord, so my lord, and third candidate is not appointed, my lord.
Second has refused. That is also stated.
Yes. But Mr. Sharma, your argument will fail
So I may be call for R Mojumdar to,
because your argument will fail you.
yes, yes, my lord.
You understand why
Yes,
your
my lord.
argument is failing you.
So I may be allowed, my lord, call R Mojumdar to,
Okay, because your argument is self-defeating.
yes. After
Okay.
some time, my lord.
After some time,
Yes.
we'll take a break and come back. It was on time.
Yes.
Yes. After some time, you may be able to call another matter. Yes.
Yeah, please, your lordship. Well, the petitioner wants to withdraw this petition, man. Lordship may allow to withdraw.
All sides are represented. Upon instructions, Mr. B.K. Das, the counsel for the petitioner, seeks to withdraw this petition. Prayer is allowed. Matters stands dismissed on the. Any interim order is operating? No. Any
No interim.
Item 8.
Pass on for timing loss. Go is here loss.
Okay.
CNG case loss. Alright.
Item 9. Item 9.
ইয়াতে এফিডেভিট আমি দিবলগীয়া আছিলে চম্পা শুক্লবৈদ্য It went 17. My এফিডেভিট দিয়া আছে
My lord, may I please also? For a time being, my lord.
ভেৰিফাই কৰি লওঁ ৰ'বা। ইয়াতে কপি আছে তাত বা আছে নাই
Up to
We will require an office memorandum dated 14/7/2016.
14/7/2016. My lord, that is available in the affidavit filed by the principal of the school at page 10.
Yes.
Lordships will allow me one indulgence, my lord.
For affidavit.
My lord, my record here shows an office copy of an affidavit in opposition. Yesterday, when I checked the status, I could not find the direct name of the director filing an affidavit. But whether the affidavit had been filed, my lord, that
No,
record
there's no affidavit here.
then perhaps
It is
this
only by
office copy-
respondent number 4. The affidavit here on record is of respondent
My
number.
lord, the affidavit
just a
here
moment.
shows that in 2017, we had kept an office copy. I do not know why it came into file. I can simply have a,
There's an affidavit of respondent number 4.
yes, my lord, there is an affidavit of respondent number 4. I saw that in here. But this respondent number 2's affidavit, my lord, I have an office copy, but the filing is not shown. Lordship gives me,
Just a minute.
this time, my lord, I can have this filed by the present director.
Just a moment. That's something I have to see from this OM dated 14/7.
My lord.
Just show me your that draft affidavit. Okay. We'll give him some time to file an affidavit. Uh, Both sides are duly represented. Mr. R. Mazumdar, Leonard, standing counsel for the Secondary Education Department has submitted that our draft affidavit in opposition by respondent number 2 is available in their file, which was prepared when
2017, my lord.
prepared
The 2nd of August, 2017.
2/8/2017. However, it is submitted that he is not aware whether or not the said affidavit is filed. The record does not reveal filing of such affidavit on record. Next, accordingly, on the prayer made by the Learned Standing Counsel for the Secondary Education Department, matters stands adjourned to enable the respondent numbers 1, 2, and 3 to file the affidavit in opposition at least 2 days prior to the next date of listing. Next, list on 8/5/2023. You have fixed it on 8/5. Prior to 2 days you file it. 8/5. My lord, can it be on 11th, my lord? 11th. Any other, either 10th or 12th, my 12th, okay, 12th, 8, 12/5. Yes. Mr. Mazumdar, this case, I think, deserves to be allowed.
My lord,
This case deserves to be allowed.
the affidavit goes otherwise, my lord. Affidavit, my lord, goes otherwise.
No, but the affidavit, the argument is self-defeating.
Oh, some other matter. Sorry. I was on the earlier matter, I'm sorry.
Oh, okay.
Information, no?
Syllabus expired, I am.
একদম দর্শক গন্ডগোলটা কি?
তিনজন প্যানেল লিস্টত তিনজন নাম দিছে
হ্যাঁ।
এই একজন দুইজনে তো এমন রিকোয়েস্ট করছে এমন অ্যানোমালিস করছে এতে এমন থাকে তো এমনতে অ্যাপয়েন্টেবল অ্যাজ বিকজ এটা আমি এক্সপার্ট বলি করে দিছি
You see, I'll tell you, there were several names in the panel list.
Yes, ma'am.
Number 1 was not qualified. Number 2 did not join. Third came before this court issued a direction that her candidature should be considered.
Considered, yes.
Now, that was the director said after that, the inspector of schools to have the approval done. Now, this approval never came on record. And therefore, when his candidature was considered, it was rejected because the approval was not accorded, number 1. Second is that the list has expired. But if a person has rejected and this court has issued a direction to consider his
Then the list
candidature,
cannot expire within that time.
it's not expired.
Cannot expire, yes. That can expire, my lord.
Therefore, just because your authorities did not provide the approval copy to the director,
Yes.
his candidature can't be rejected.
My lord, what I find is that the district, the panel of select list prepared by the school selection committee has to be forwarded to the district approval committee. It is only after the district approval committee makes a selection of 1 candidate per post, then it becomes a select list. Here it is a 3-person list. It is not yet a select list.
No. There was approval given to 1,
Yes,
not qualified.
not qualified.
Approval given to number 2, did not join. For third, approval never came. And you can't even say that by making an offer to 1 person, the list has expired because you gave the approval for the second one also.
Second.
And then there's a High Court direction to consider his
Then it
candidature.
continues, then there is no issue.
Then if the
In that time, there is no
the
issue.
inspector does not give the approval, send the approval.
When there is
Can be
litigation
penalized.
pending, my lord, when there is litigation pending and a final order comes, select list cannot be said to have. Otherwise, that would have been the decision in the order itself. We cannot do so. Since there's a direction.
Heard Mr. Y.S. Manan, learned counsel for the petitioner. And Mr. R. Mazumdar, and standing counsel for the Secondary Education Department. Next para. In brief, comma. The case of the petitioner is that he is otherwise qualified for being selected and appointed as a subject teacher in chemistry, having master degree in chemistry with B.Ed degree. And she is also successfully cleared the TET examination held on 8/2/2014. Full stop. Pursuant to notice dated 15/11/2014, issued by the Director of Secondary Education, Assam, the petitioner offered her candidature for the post of subject teacher in chemistry in Samata, CHAMATA, HS school. Post. The name of the petitioner appeared at serial number 3 of the select list dated 14/9/2015. Mr. Manan, I'm right on dates. 14/9/2015. Full stop. It is projected that the candidate at serial number 1 of the select list could not be the appointment of person at serial number 1 of the panel could not be made as there was a query with regard to her degree. Full stop.
B.Ed certificate anomaly. Anomaly in B.Ed certificate.
Acha,
It has been stated in the order.
B.Ed certificate. Full stop. Therefore, although the name of person at serial number 1 of the panel was approved, the appointment could not be made, and therefore the person whose name appeared in serial number 2 of the panel list was given the approval for appointment. However, the said person did not join the post of subject teacher in chemistry. Therefore, as nothing was done with regard to the request of the petitioner for providing approval for the approval and appointment to the said post, the petitioner approached this court by filing WPC 6565 of 2015.
Chemistry, subject teacher chemistry.
Full stop. In connection with this said petition, by an order dated 16/10/2015, this court directed the Director of Secondary Education Assam, within bracket respond number 2, to consider and take a decision. Where is that page?
Page
Court order.
36. And page 37 is the relevant part. Last paragraph.
You just write the observations and direction of this court. Is as follows, page 37. Take note.
Last paragraph without.
Full stop. Next paragraph. As the direction of this court as contained in the hearing before referred order dated 16/10/2015 was not complied with, the petitioner approached this court in a contempt jurisdiction by filing filed a contempt petition which was registered as Concase C 250 of 2016. Full stop. It is projected that during the pendency of the contempt petition, direction was issued by the respondent number 2 to place the matter before the district level approval board and submit a report. Full stop. Thereafter, by the impugn order dated 23/5/2016, the candidature of the petitioner was rejected by the respondent number 2 by holding that no approval report had been received from the Inspector of Schools, Nalbari District Circle till date, and that the select list, select on the panel list had expired by lapse of 1 year from the date of preparation of such panel list. So accordingly, the petitioner has filed his petition under Article 226 of the Constitution of India to assail the impugn order dated 23/5/2016, passed by the Director of Secondary Education Assam, within the respondent number 2. Next, the learned counsel for the petitioner has submitted that as the petitioner had approached this court within the validity of the select panel list, it is not open to the respondent authorities to reject the candidature of the petitioner on the ground that the validity of the select panel list has expired. In this, let me write the name of the parties because it's otherwise difficult. First of all, in this connection, the learned counsel for the petitioner has referred to the following cases. First of all. Next one. Per contract, the learned standing counsel for the secondary education department I suppose the prayer made in this petition by extensively referring to the affidavit in opposition filed by the respondent number 2 on 4/5/2019. Full stop. It is submitted that the petitioner, whose name was enlisted in the third position in the panel public select list, but as her name was not recommended by the district approval committee at the relevant point of time, the petitioner cannot be appointed, could not be appointed as postgraduate teacher in chemistry in Samatha Higher Secondary School. It is also submitted that the approval accorded during 2013-14 for appointment of postgraduate teacher had already expired on 31/3/2016. And as the competent authority did not extend the validity of such approval of the panel list, the petitioner could not be appointed. So it is submitted that although direction was issued by the respondent number 2 to the inspector of schools, Nalbari, within bracket respondent number 3, place the matter in the district level approval committee for their recommendation and to submit a report. But as the approval and report of the inspector of schools was not received by the respondent number 2, no case was made out for appointment of the petitioner to the said post. So it is submitted that the petitioner cannot get the benefit in this case, and he would not, and she would not be entitled to be offered appointment on the ground that the school selection committee of Samatha Higher Secondary School had not followed any proper procedure in selection process for the post of subject teacher in chemistry. Next paragraph. Consider the materials available on record and as well as the submissions made by both sides. Next paragraph. The court finds that the decisions cited by the learned counsel for the petitioner make it abundantly clear that if during the validity of the select list, the aggrieved persons approach the court, it would not be open to the selecting authority to take a plea that the validity of the select list has expired. it will suffice to refer to the to para 17 and 18 of Satpal within bracket Sutra and para 26 of A. Dhananjay Singh within bracket Sutra, which are extracted below. Next para. Therefore, in respect of the issue raised regarding the validity of this select of the panel list, the court is inclined to, well, under the facts and circumstances of this case, the court is inclined to hold that the provision of clause 12 of Rule 8 of the Assam Secondary Education within bracket provincialization bracket close service rules, 2003 would not be operative owing to the fact that during the pendency of the select list, during the validity of the select list, the petitioner had approached this court by filing WPC 6565 of 2015, and this court by order dated 16/10/2015 had disposed of the writ petition by directing the respondent number 2 to consider and take an appropriate decision on the recommendation of the respondent number 3 conveyed by letter dated 19/9/2015 within a period of 3 weeks. This was followed by filing Concase C 250 of 2016, and when the candidature of the petitioner was rejected by the impugn order dated 23/5/2016, the petitioner has approached this court by filing this petition on 30 January 2017. Therefore, in view of the ratio laid down the 3 cases cited by the learned counsel to the petitioner, the court is inclined to hold that the petitioner had approached this court within the validity of the select list, and therefore the select list cannot be held to have lapsed under the facts and circumstances of this case. Next paragraph. Insofar as the issue of non-availability of the approval by the district approval, what is it called? District level approval committee.
District level
Approval committee. District
It is
level
called
approval
the-
committee of Nalbari district is concerned. How the court finds that it is seen that this could be order dated 16/10/2015, asked in WPC 6565 of 2015, had directed the respondent number 2, i.e. the Director of Secondary Education Assam, to consider and take a decision on the letter of recommendation dated 19/9/2015. Full stop. Under such circumstances, it was the duty of the respondent number 2 to take a decision. Full stop. If despite direction by the said authority to the subordinate officer, I, the Inspector of Schools, Nalbari District Circle, within bracket respond number 3, to place the matter before the district level approval committee, comma, the respondent to ought to have pursued the matter so as to ensure that his orders are complied with, his orders or the directions as contained. Where is that direction of the director to inspector?
That is page 39.
It's by order number GB dash EST. How do you, this page 39, huh?
Page
Dated
13.
14/3/2016. So therefore, if the inspector of schools, NDC, Nalbari, has not complied with the directions contained in the order dated 14/3/2016 by the Director of Secondary Education Assam. This was a clear case of inaction on part of the respondent authorities. To comply with the said order dated 14/3/2016, which is a clear-cut case of non-compliance of the order of this court dated 16/10/2015, passed in WBC 6565 of 2015. So therefore, the court is of the considered opinion that the respondent authorities, having shirked as such RIKD of its responsibility to comply with the order of this court, that is 16/10/2015, passed in WBC 6565 of 2015, comma, they ought not to be allowed to take shelter of the non-granting of approval by the district level approval committee. Full stop. Next, under the circumstances, the non-granting of approval by the district level approval committee would not preclude the court to hold that the petitioner, whose name appeared at serial number 3 of the select of the panel list, prepared on 14/9/2015, had an indefeasible right to be offered approval by the district level approval committee for appointment as subject teacher in chemistry at Sonata Higher Secondary School. The district level approval committee cannot have an independent choice of not making an approval during the validity of the during the validity of the select test, unless they rendered a opinion questioning the eligibility criteria of the eligibility of the petitioner for being appointed to such post. As such a ground has not been taken by the respondent authorities in their affidavit in opposition. Withholding of the approval by the district level approval committee is deprecated and disapproved. Full stop. Accordingly, the court is inclined to direct the respondent number 2, I, the Director of Elementary Education, Secondary Education Assam, to ensure that his order number so and so dated 14/3/2016, page 39, is brought to its logical conclusion within a period of 1 month from the date of service of the certified copy of this order. Full stop. While granting approval, while considering the candidature of the petitioner, the district level approval committee. In this regard, the Director of Secondary Education Assam shall also issue a supplementary direction to the district level approval committee not to reject the candidature of the petitioner on the ground that the select list is expired, and therefore the appointment of the petitioner shall refer back to the select list prepared on 14/9/2015. Next part. Insofar as the third ground taken by the Learned Standing Council for the Secondary Education Department, that the school selection committee of Samata Higher Secondary School had not followed any proper procedure in selection process for the post of subject teacher in chemistry is concerned, the said ground does not appear to hold any water, on the ground that such an objection was never raised when approvals were granted and offer of appointment was made in respect of the persons whose name appeared in serial number 1 and 2 of the said select list. Full stop. Therefore, the court does not find any merit in the said stand taken by the respondent number 2 in paragraph 11 of the affidavit in opposition. Next one. This, in view of the discussions above, the restriction stands allowed by setting aside and questioning the impugn order number so page 40, dated 23/5/2016. As a consequence of the setting aside of the impugn order, the for the petitioner, the select of the panel list dated 14/9/2015 in respect of subject teacher in chemistry of Samata Higher Secondary School stands revived. We can make it passes the following order number 1 to 3. The third would be the respondent number 2, I, the Director of Secondary Education Assam, shall issue a supplementary direction to see that, to ensure that his hearing before referred order dated 14/3/2016 to the Inspector of Schools NDC Nalbari would be brought to its logical conclusion within a period of 1 month from the date of service of the certified copy of this order before the Director of Secondary Education Assam. So the said authority shall also issue a supplementary direction to the Inspector of Schools NDC Nalbari as well as the district level approval committee, Command Albari, that the candidature of the petitioner should not be rejected on the ground that the validity of the list has lapsed, inasmuch as the court has restored the said select list for the petitioner. Next para. The next para again, not sub para. This para. As this order has been passed under the unique facts and circumstances of this case, comma, and court is inclined to verify that the restoration of the select list shall not be treated as a precedent for any future matters, as the select list has been derived under the unique facts and circumstances of this case. Next, brother. Parties are left to bear their own cost.
Dispose.
You want to be alive? You want it to remain?
No, you're not, you have not used the word disposed of. This is
No,
my-
I said aloud. So
Oh.
when I start, I said aloud with the following directions.
So they have to submit a copy to the director and then he will issue the subsequent notice. Much obliged.
Item number 10,
Mr. Mazumdar, any factual incorrectness in the order? If But even if you make out a case, we can't issue a direction for your provincialization.
but my lord, that order of cancellation, my lord, passed, my lord, during the pendency of the. appeal.
Before provincialization.
So you see. It's a question I'm trying to make it as soft as possible. If I ask a general person a question, would you like your children to be imparted education by a person who was accused of 302 and imprisonment
Yes,
for 5 years? If I ask this question to any general person,
But the procedure has to be followed, my lord, but I am only that.
no, once you have been convicted, what 311(2) will do
Yes,
to you?
Yes, that's too well, but the order, my lord, the passed, my lord, during the pendency of the appeal before this honorable court, my lord, that is prior to that.
No, but still today, as on today, 5 years imprisonment is there on
Yes.
302.
Yes,
What disciplinary proceeding will do to you?
but the order, my lord, that has passed, my lord, cancelling, my lord,
You can't be restored. It will be only an what you call empty formality. You can dispense with it. 311(2) can be dispensed with it. When there is no other what you call viable alternative. You see, with that conviction of 5 years under 302, that conviction has not been converted to an acquittal.
not.
Right. So assuming that the 311(2) disciplinary proceedings is initiated, what will happen? It will lead to the same result. Because if I ask a general person, would you like your children to be imparted education with a convict who is sentenced 5 years of imprisonment under 302? I don't think anybody will say yes. Except for yesterday, there was a cartoon somewhere. Ah, yes. In yesterday's newspaper, Times of India, there was a cartoon of Hagar the Horrible. Have you read that? No. Hagar the Horrible is otherwise an uneducated person, does not know read to write. So in the prison, he asks a question to the co-inmate. I think I have spent time reading and writing. The other convict says, don't do it because I did that and I am now in for forgery. That was yesterday's Times of India. If a convict learns reading and writing, he said that I am here again for forgery.
Here, my lord.
Except for one set of persons who may like to be graduated in crime, I don't think anybody will permit that teacher to be a convict in 302.
304 part 2.
What will be 302 converted to 304 part 2? 311 2. You have a decision. 311 2. There is no inquiry required. It can be dispensed with.
Only matter may be taken any other.
311 2. Constitution. Even the Assam Discipline and Appeal Rules also give the same power, my lord. Rule 10. In case of a conviction, we just have to inform him as to why he should not be terminated from on the ground of his conviction. No inquiry required. We can take a decision.
Where is that?
Assam Discipline and Appeal Rules does not even require a notice, if I'm not wrong. We can simply take into account the Rule 10 of the
Rule
Assam,
10.
my lord.
তাৰ কনভিকশ্যনৰ পাছত এইটো SMC ৰিজলিউচন কৰি তাক টাৰ্মিনেট কৰিছিলে তাৰপিছত আকৌ প্ৰভিন্সিয়েল ইলেকশ্যন অৰ্ডাৰত নামটো আহিলে যে তাত সেইটো মানে সেইটোৱে সিহঁতে ধৰিছে সেইটো 311 মানে তাৰ হেৰিটো ৰাইটটো সেয়া কৰে বুজিছে সেইটোত লাগে এনেই বুদ্ধি চাব লাগে আৰু ইটো মানুহো 10 বছৰ হ'ল কৰিবা এটা দিলেও হৈ যাব
কি judgment? কি বুলি?
সেয়া মানে সেয়া নাপাইছে
কি নাপায়?
মানে কোনটো দিবলৈ দিলে নহয় সেয়া ৰুল 10ৰ ওপৰত
Yes. Some discipline notwithstanding anything containing in Rule 9. When a penalty is imposed on a public servant on the ground of his conduct which has led to his conviction on a criminal charge, the discipline authority may consider the circumstance of the case and pass such orders. No notice is required. I don't know, but this is what we can do. I take it down to pizza.
মানে কি হ'ল টাৰ্মিনেট কৰাৰ পাছত সেকেন্ড ফেজতে তাৰ জেগাত এপইন্টমেন্ট দি দিলে তাৰপিছত কিন্তু প্ৰভিন্সিয়েল ইলেকশ্যন অৰ্ডাৰত তাৰ নামটো আছিলে সেইটোতে আহিছে সেইটোৱে তাক কি কৰিলে এতিয়া চাকৰিটো কৰিব লাগে আৰু সেই কনভিকশ্যনৰ সি লাইফ টাইম ইমপ্ৰিজনমেণ্টৰ পৰা ওলাই আহিলে
This is 11-13.
Provincialization order.
Where is this?
Where is the impugned order?
My lord, that lordship will find in the page 31. This is the information provided in RTML.
Hello. Provincial está pasando eso. Forward to voice.
Okay.
My lord, only
Mr.
one.
Sharma, I'll be dismissing this. Yes, you want to say something?
Yes, my lord, my lord, my only submission is that the post has been provincialized, my lord. And my lord, after provincialization, my lord, the managing committee has no role, my lord. But in the impugned resolution, my lord, that lordship will find in the page 35, my lord. That was by the managing committee, my lord. That was, my lord, subsequently passed order by the director.
Your post was provincialized.
Yes, my lord. That lordship will find
Okay, then you have a ground. It has to be by the director.
is my lord.
The termination has to be by the director.
But
Is 1-5, my lord.
the issue here is he was terminated prior to his provincialization. Documents
Sir,
which
Shama
were
says
sent,
no.
documents which were sent for provincialization, that did not contain the fact that he was terminated or he was convicted. So documents placed before the director did not contain those two facts. Therefore, the provincialization order came in such a manner. Therefore, the provincialization is not done
Provincialization is
after knowledge by the education department that he has been terminated or that he has been convicted, because after his conviction, he was terminated by the school managing committee. By that time, the papers had already been sent to the director for consideration for
Where is
provincialization. That is how it went ahead, my lord.
From where do you find that?
that provincialization page 15, my lord, order dated 14 May 2013. And the,
No, give me the relevant dates. Your
my lord,
conviction is dated.
conviction is the, my lord, dated 29/11/2012.
No, sorry. The alleged incident happened when?
My lord,
Alleged incident that murder happened when?
my lord,
Happening of the incident, my lord, he has not
So-
stated.
so- no, you see, Sessions case was registered in 2009.
Yes.
So
yes.
it has to be 2000, what do you call it? Case number is, it should be
In-
2009
incidents prior
only.
to that.
2009, we'll take it
Yes.
2009 for the time
Yes.
being.
Now, the application form was sent on 29/11/2011.
No, then just a moment. Incident of 2009,
9.
conviction
2012.
29/11/12.
29,
11,
11, 12. The conviction was for life.
Life.
Yes.
This was converted to 5 years by the Sessions, sorry, by the High Court.
Yes,
By the High Court.
16/8/2016.
16/8/2016. Converted to 5 years.
My lord,
Yes.
Now this
is released on 15/10/2016.
15/10/2016.
16 he is released.
Released. Yes. Now your provincialization,
Provincialized on, my lord, 14 May 2013.
Application is sent on 29/11/2011.
29.
11/2011.
Yes.
He was terminated from service
By the managing committee
by
on,
the
my lord,
managing
17/12/2012.
17/12/2012, prior to his provincialization.
And by the director, my lord, on 26/11/2013.
By the director, I didn't follow you. Please repeat again.
My lord, the director has subsequently passed an order, my lord.
Terminating of service.
Yes.
Where is that?
That, my lord, I have not annexed that order, but that observation in the, my lord, page 31, last line.
Page 31.
My lord. Because the, my lord, respondent number 7, my lord, approached before this honorable court, my lord. And this honorable court, my lord, directed him to submit a representation, my lord. And in that representation, my lord, I am not the party.
Okay.
না না এই কন্ট্রাকশন এটা কি আছে না এটা দেখাই না ইয়াতে দেখা নাই রিপিটিশনতে নাই
Mr. R. Sharma, learned counsel for the petitioner. And Ms. N. Fukan, learned standing counsel for the Elementary Education Department, appearing for respondent numbers 1 to 4. Who is appearing for 5 and 6? You are there. Name? Mr. A. Hussain for respondent numbers 5 and 6. And who is number 7?
7 I'm also. 7 I'm also.
You 7 also. Okay, so 5, 6, and 7. Next one. In brief, comma, the case of the petitioner is that he was appointed as an assistant teacher in the Azad AZAD, Azad LP School, Lakhimpur, which was then a venture school. Full stop. The service of the teaching and non-teaching employees of the said school was sought to be provincialized, and accordingly, in the prescribed format, the name of the petitioner along with others were forwarded for being considered for appointment as subject teacher, assistant teacher, for assistant teacher. Full stop. The by an order dated 14/5/2013, the service of the petitioner was provincialized by the Director of Elementary Education Assam within bracket respondent with 2. Full stop. The petitioner was found involved in a criminal case and accordingly, in connection with trial of Sessions case number 43 within bracket NL bracket close 2009 under section 302/34 IPC, the petitioner was convicted and sentenced for life imprisonment. Full stop. The aggrieved petitioner approached this court in appeal, and this court, by judgment and order dated 16/8/2016, passed in criminal appeal 40/2013, upheld the conviction but converted the sentence from life imprisonment to imprisonment for a term of 5 years. Full stop. Resultantly, the petitioner was released from jail on 15/10/2016. Full stop. On his release, the petitioner had submitted an application before the District Elementary Education Officer, Lakhimpur within bracket respondent number 3, to allow him to join this school. Full stop. As nothing happened, the petitioner made an RTI query, and in the RTI reply, the petitioner was informed that his name was replaced by the respondent number 7 by the impugned resolution dated 17/12/2012, which was taken by the managing committee of the said school. And the petitioner also became aware that the Director of Elementary Education Assam, by the impugned order dated 26/11/2013, deleted the name of the petitioner from the list of teachers whose service were provincialized. Full stop. The case of the petitioner is that he has not been served with a copy of the said order dated 26/11/2013. So accordingly, the petitioner has approached this court with a prayer for setting aside the resolution of the respondent number, resolution dated 17/12/2012, taken by the respondent number 5. For setting aside the order dated 26/11/2013, issued by the respondent number 3. And for setting aside the order of respondent number 2 dated 26/11/2013. No, respondent number 3 dated 26/11/13. Next paragraph. The learned counsel for the petitioner has submitted that after his service was provincialized, the school managing committee had no authority to adopt a resolution to substitute his name with that of respondent number 7. And any resolution taken before the same, before this provincialization of service would not be effective. It is submitted that as the service of the petitioner was provincialized by order dated 14/5/2013, the state could have terminated the service of the petitioner only by following the procedure, due process of law, by taking recourse to the Assam Services within bracket discipline and appeal bracket closed rules from 1964, by complying with the principles of natural justice. Full stop. It is also submitted that having provincialized the service of this petitioner, the respondent number 3 could not have refused the prayer of the petitioner to join service, and that the inspector of schools also did not have authority to delete the name of the petitioner. Next paragraph. For contra, the learned standing counsel for the Elementary Education Department has submitted that although the date of the alleged criminal act of the petitioner is not on record, but as the trial commenced in the year 2009, it can be tentatively accepted that
this is, my lord, on 2010-2009,
2010-2009. Okay, 2010-2009.
page 20, my lord.
Comma. But the process of provincialization has commenced on and from 29/11/2011, when the papers were submitted before the authorities. Full stop. Although the petitioner was convicted for life by a judgment of the Learned Sessions Court dated 29/11/2012, comma. Prior to it, on 17/12/2012, comma, a resolution was taken by the respondent number 5 to delete his name, to delete the name of the petitioner. So how, as these subsequent events was not brought to the authority, brought to the notice of the respondent authorities, comma, in the meanwhile, the respondent number 2, by an order dated 14/5/2013, had provincialized the service of teaching and non-teaching staff of Azad LP School, Lakhimpur. So it is submitted that as the conviction of the petitioner came to the notice of respondent number 2, by an order dated 26/11/2013, the name of the petitioner was deleted. Accordingly, it is submitted that the disciplinary proceeding, comma, if initiated against the petitioner, will be an empty formality, as the petitioner has already been convicted of offense committed, offense under section 302/34 IPC, and the petitioner had spent 5 years in custody as convict. I'll resume at 2. I'll take a break and come back.
Item 18, 19, 20, 21, 23. Affidavit filed by a person against him, no affidavit filed by a sub-state. No affidavit filed by 22, এটা ভুল হলো। আমি ভুল রেকর্ডটা বিচাৰি ফুৰিলো, অলপ ভুল হ'ল, সেইটো will file it by nature. Personal appearance দিব নালাগে।
Court number 24 এটা judgment আছে। সেইটোত মই এবাৰ যাম।
কিয় জাজমেন্ট অফ কি কৰা তুমি কেছ কৰিবা জাজমেন্ট
আমি যাব লাগিব।
জাজমেন্ট পিছতো পাবা।
না, না, যাব লাগিব।
Always good. As you want idea of this, so it is probably খালি নয় আমি স্ক্যান করে দেবো ওখানে তো টাইম দিলা তখন আইটা বলে দেবো কারণ এগুলো তো না ইনস্ট্রাকশন পাইতে পিডিএস এ ওইগুলো ওগুলো ভালো কি মানে হ্যাঁ বলে এই যে ওখানে যে স্কুল তখন যে ইনস্ট্রাকশন আপনি যে ইনস্ট্রাকশন তো সেকেন্ড ডিপার্টমেন্ট করেন এটা প্রদীপ কি প্রদীপ তালুকদার কি না প্রদীপ মডেল এটা কার হচ্ছে আপনি সেকশন কি গভর্নমেন্টের বিটেক দেখেন নেট অ্যামাউন্ট জায়গা গ্রস অ্যামাউন্ট জায়গা নেট অ্যামাউন্ট সেকশন দিতে আরে এটা এই কারেকশন তো পুরো বলবো আমি করি নেট ফাইন্যান্সে বলবো $69,000 এটা এরকম মোটা এটা দুটো কিডনি গুলো বলে এগুলো বুঝে ইমাম সময় লেগে আহিলে একেলগে নাহে নেকি মানে কারটা আহিলে দেখো ডিস্ট্রিক্ট কোনে বিভিন্ন রকম ডিস্ট্রিক্ট এলিমেন্টারি এডুকেশন অফিসার এই সেকশনের পিছনে নন রয়্যাল দিয়ে না সেকশন আগরে নন রয়্যাল দিয়ে এটা বুঝাইলো প্রপোজালটোৰ লগত একেলগে এই নন ৰয়্যাল কথা বলবো না যেহেতু প্রপোজাল আর একেলগে এই পয়সাটো ড্ৰ কৰা নাই সেইখনতো নন ৰয়্যাল সেই 13,000 ড্ৰ কৰা নাই কিন্তু একেলগে বোলে প্ৰপোজাল লগত নপঠায় দিনত লিষ্ট কৰিব লাগিব হ'ব তাৰপিছত কিন্তু কোটা টাইম দিব আৰু মই দেখ দিলে এখানে নেই মানে রেজিস্ট্রেশন কি হয়েছে বুঝ না রেজিস্ট্রেশন আইটেম 24 পাসওয়ার্ড কি না इसका कैटेगरी के बैनर फिल दे दी तो किसको प्रॉब्लम होगी की कोई है তাহলে কি দিই যখন কোম্পানি পার্সোনালি সব করে দেব তাতে কি সলিউশন আর সলিউশন Once I actually because I am under suspension now. I'm not being able to her. তুমি পাবে ডকুমেন্ট দিয়া নাই মোবাইল কেন এলাও করছে তুমি এটা বলি কি দিও এতিয়া তুমি কবা যে মোৰ ৰিপ্লাইটো ৰেফাৰ কৰক যাবলৈ কেউ ভাবিলি কৈছিল মই লিখি দিছো কিন্তু ৰেকৰ্ড বুজিছো what record are you asking for which record do you need specify the record that you want when I read the student that you will be delivered director of no if you want to check what কাগজ তোমার assembly লিখি দিব না রিপ্লাই দিবেন there can be only one reply the one reply to করে দিছি যে when it will be technically to fake it but it's it was also involved by the director sí, the direction is on STF.
051. 300 MBPS.
Charge, but asking me questions all around is not going to work. Is it a charging incident? Or is it Ah. Very well, then start the proceeding. If the authority is not satisfied, starting proceedings. Authority cannot wait for your satisfactory return, Baba. We take it as a motion, we require a response, we can Why people get like what are these? In case you are satisfied, kindly accelerate it, give them a question. In case you are not satisfied, according to the procedure in accordance with law.
Am I able to? So when I give
Why is not that we can make that monetary, but it's been only whereas we did last motion of regard to retail. I have already given my reply to Chashi. I am not asking further questions from the disagree or to explain the status. Further explanation of your. The one who will get reply that is part of the evidence. Tomorrow gets it, my employee evidence to take what it is not. Simple thing is, how much reply to why can I explain to you? To the best of my capability, I can deliver it. 1 month.
আপনার দাদা দমে করিয়েছিল আপনার ভাইনে দাদা ফ্যামিলি মানে আপনি রাজ্য করে আপনার রাজ্য রাজ্য গাড়ি এটা পাই পাঁচটা জমাতে গাঁও গাঁও মানে রাতি 9টা বাজে 10টা পর্যন্ত এটা টাইম টু বেয়ার রাইজৰ এখন ভাল স্পিড ওটা কোৱাৰ স্টপেজ দিয়ে অলপ ৰয় কিন্তু চলিলে স্পিডত চলে
আৰু এনেতো ডেইলি এখন অপডাউন কৰে আৰু এখন দিছে এখন গুৱাহাটী এইখন না হাতে এইখন আহিছে কি হাতে সেজন মোক কল এইখন গুৱাহাটী ভাই তিনচুকীয়া দিছে না দুদিনকে এখন সপ্তাহ তুমি নিপিলে বহুত স্পিড বিরাট নাম্বার ছটা মতো ভুলে গ্রোথ করে পাঁচটা মতো তার বিষয়ে দেখো
লাখ ভাল বুলি কৈছে number 6 to 7 is more six.
অলপ চাইলো ইয়াত থাকে নে তোমাৰ ঘৰত চেম্বাৰ থাকে ইয়াৰ পৰা জেৰক্স কৰি লওঁ হা
এনেওতো ইনফ্ৰাষ্ট্ৰাকচাৰ হৈছে
নাম্বাৰ আছে পিটিশনৰ কমেন্টৰ পিটিশন ৰিপ্লাই আছে এখন জাস্ট কৰিবা আৰু মোৰ ৰেকৰ্ডৰ পৰা আমাৰ এই ৰিপোৰ্ট
নাই নেকি
এটা কপি আছে আজি কোন আছে হিন্দি টেস্টেশন আছে হিন্দি কিছুমান ডকুমেন্ট আছে আমার নাই যদি জেরক্স করে দিবা মানে আমার ফাইল খায় নাই এই
Can you continue over there? Next, it is noted that the respondent number 7 had approached this court by filing WPC 2051 of 2013 claiming placement of his name as first assistant teacher in what is the name of the school? Is it Azad LP School? Azad LP School, Balitika, Balitika. By projecting that the petitioner was the first assistant teacher of the school, his name was dropped on being convicted. In the set hearing before referred criminal proceeding, and further projecting that the service of the petitioner was terminated by resolution dated 17/12/2013 First off, although the learned counsel for the petitioner has successfully demonstrated that the petitioner was not implemented in WPC 2051 of 2013. But nonetheless, this court had directed the Director of Elementary Education of Assam to make a necessary inquiry in the nature as provided on section 10 within bracket 4 of the Assam Venture Educational Institutions within bracket provincialization of services bracket closed act, 2011. And thereafter, for effective modification in the particulars of the school in question. Full stop. Where is that order of the where is the order of the director? Which
My lord,
page?
My lord, page 31 it is reflected, my lord. That's order. I don't know. Page 31, my lord, last part.
So it's happening that when the respondent number 2 had deleted the name of the petitioner by order dated 26/11/2013 and included the name of the respondent number 7 as assistant teacher in his place. The petitioner was incarcerated in jail to suffer conviction. Next page. Well, it further appears that on 12/12/2012, when the executive committee of the Azad LP school had taken a resolution to terminate the service of the petitioner, at that stage, the school of the concerned Azad LP school was still in a venture stage. Full stop. Therefore, comma, the termination of the service of the petitioner became effective with effect from 17/12/2012. Full stop. At that stage, the petitioner was convicted and sentenced for life imprisonment, which was subsequently ordered by, was altered in appeal. Full stop. Therefore, comma, on 14/5/2013, the service of the petitioner was provincialized. By the time the petitioner was already removed from the service of the petitioner was already terminated from the school. Stop. Therefore, comma, when the Director of Elementary Education Assam had passed the order dated 26/11/2013, deleting the name of the petitioner and including the name of the respondent was served as assistant teacher in his place, comma, in the considered opinion of the court, comma, he was only implementing the status of the petitioner in the school. Which was to the effect that the service of the petitioner had already been terminated by resolution dated 17/12/2012. Next paragraph, under such circumstances, comma, merely because the name of the petitioner was included in the provincialization order dated 14/5/2013, would not have the effect as if the petitioner became a member of the cadre of assistant teacher under the Directorate of Elementary Education Assam. Full stop. On 26/11/2013, when the Director of Elementary Education had deleted the name of the petitioner, comma, the petitioner had not joined and was serving in the said school, i.e. Azad LP school, as he was serving sentence imposed on him. Full stop. In that view of the matter, the court does not find that in order to effectually terminate the service of the petitioner, the state was required to follow the procedure as prescribed under the Assam Services within bracket Discipline and Appeal bracket closed rules, 1964. Next one, even assuming that by dint of the provincialization order dated 14/5/2013, the petitioner was deemed to be a government servant, notwithstanding whether he had joined or was serving in the school in question. The fact that prior to the order of the director dated 26/11/2013, the managing committee of the Azad LP School had the power and authority to remove the petitioner from service. Merely by provincialization of service, the petitioner would not get the status of the assistant teacher in the said school on his service being already terminated. Just under such circumstances, the court does not find that any reason for the authorities in the Elementary Education Department to initiate a disciplinary proceeding against the petitioner. So what was actually done by the Director of Secondary Education from Assam is that he had made effective the status of the petitioner, which flowed FLOWED from the resolution of the school managing committee taken on 17/12/2012. As the petitioner was no longer serving in that said school, otherwise service could not have been provincialized. Under such circumstances, the present litigation fails and the same is dismissed. Parties are left to bear their own cost. Mr. Mazumdar is here.
Yes, madam.
You got the information from Mr. Goswami.
Yes, my lord, yes.
Huh.
My lord, the proposal for the rest of the amount has been received by the office of the director, my lord. We are processing it. We just need the time for it to be sanctioned from the government and we can pay it.
Okay,
They have given an estimated time within the month of May. We'll try to have the payment made.
okay.
We received the
So
proposal
Goswami, we
today.
can't help it. Let that be processed. We'll have to spend some more time here. Mr. S.K. Goswami, item number two. Mr. S.K. Goswami, then counsel for the petitioner is present. Mr. R. Mazumdar, then standing counsel for the secondary education department.
Elementary education.
Elementary
This is
education
elementary.
department has submitted that he has a telephonic discussion with the authorities of the Directorate of Secondary Education, Elementary Education
Elementary.
Assam, who have informed him over phone that
The proposal has been
the
received.
proposal for the releasing of the funds of the petitioner has been received, which is being processed at the appropriate level.
My lord.
The next, the Learners Standing Council for the Elementary Education Department expects that the matter would be resolved within
4
a
weeks.
month. Next paragraph. Considering the fact that this is a repetition of the year 2016 and the petitioner has been waiting for a very bigger amount. We could expect hopes and trusts that the Director of Elementary Education Assam shall bring a quietus to the issue within a period of 4 weeks from
4
today.
weeks.
First one. Next, the Learned Standing Council for the Elementary Education Department shall send a copy of this order to the Director of Elementary Education Assam. Bring the order to the notice of the said authority. Next, list on 2/6/2023.
Done.
Try to see if we expedite it.
Obliged.
Obliged.
Just a moment. Just add one more line. It is further provided that in the event the petitioner is found entitled to the money claimed, the pendency of the rate petition shall not be a bar for the respondent authorities to transfer money to the account of the petitioner. But you'll need to give him some account details and all.
Already, I already
They have it. Okay.
Item number 5.
My lord, on the last occasion, Lordship had raised a query regarding the term of a SMDC.
SMD.
Now, my lord, there is an office memorandum of 2014, which laid down that the life of the SMC in high schools and high secondary schools would be 5 years.
So
That is gone. The my lord, thereafter 2016, there was another office memorandum which did not touch that term, but laid down different process for the
concern is that
president.
time is
Otherwise,
5
it is
years.
5 years.
This is gone.
5 years. It is gone.
None appears on call for the petitioner. However, Mr. R. Mazumdar is standing counsel for the Secondary Education Department,
Yes, ma'am.
and Mr. F. U. Babia, learned counsel for the private respondent.
4 and 5.
Number 4 and 5 are present. Next paragraph. In this writ petition, the petitioner has challenged the constitution of the School Management and Development Committee within bracket SMDC for short bracket closed. In respect of Asimia ASIMIA Higher Secondary School, Karimganj, and the select list of the principal dated 29.
But that they had given up. Lordship. Order dated 25/1/17. They've given up that.
29/11/2017. So stop. It appears from the order dated
25/1/2017.
25/1/2017, passed in this writ petition that the petitioner has given up the challenge to the select list of principal dated 29/11/2016. Full stop. It appears from the provisions of the Assam aided higher secondary, high and middle English schools
Provincialized, right?
management rules,
This is-
1976.
This is a provincialized school, my lord. It's not an aided school.
It's not aided.
It is provincialized school.
So which will be the rule?
My lord, that is governed by an office memorandum, my lord.
Okay,
just
it
made-
appears that the term of the school of the SMDC is 5 years
5 years.
as per notification dated
2014 notification. Yes. 6th of August 2014.
14. Full stop. In this case, the SMDC was constituted on 18/10/2015, right?
Yes.
18/10,
18.
date is 18/10/2015. And therefore the term of the said SMDC had expired.
It is 16, my lord. 18/10, 16, here expired now.
16.
Oh, except 2021 is expired. 18/10/2016,
18/10/2016.
16, 5 years from then. 18/10/2021.
Just a moment. 18/10/2016, not 15. I'm going by this list of dates given in the writ petition.
My lord, that was
Here it is 15.
typographical error.
I don't know,
Committee goes to
16, and therefore the term would have expired on or about 17/10/2021.
21.
Full stop. Hence, the court finds substance in the submission made by Learned Standing Council for the Secondary Education Department, as well as the Learned Council for the private respondent, that as the tenure of this SMDC has expired, while the matter has become infectious. Next, be that as it may, as the petitioner is absent on call on petitioner had remained absent on call on 1/4/2021, 22/3/2023, as well as today. It appears that the petitioner is not interested to pursue this writ petition, and accordingly this writ petition stands dismissed from non-prosecution.
But may I just make one statement that it is a term of the president and the vice president, which is for 5 years. SMDC, my lord, other members, they change in 3 years. But vice president and president, so
This
just
is
before
right.
the term of the SMDC, it will be term of president and vice president of SMDC.
Instead of SMDC, term of the president and secretary of the SMDC
Vice
is for
president, president and vice president,
the vice president is for a term of 5 years,
5 years,
whereas the term of other members of the SMDC is 3
3
years.
years.
Okay.
Obliged, madam. You know, what's it?
The domestic matter may be possible for time being.
Time being.
Time being.
Well.
On the last occasion, a statement was made by the petitioner, the counsel for the petitioner that the affidavit has been filed by the respondent number 4 and the copy has been received on request of the respondent number 4, counsel for the respondent number 4, but they have not filed any affidavit on the date, and we have not received any copy of it. And even in 27/4/2018, we don't have any affidavit filed by the respondent number 4 dated 27/4/2018.
No, the submission is that here we have recorded
Yes, sir.
that you have been served with a copy.
It was on request on the part of the respondent number 4, counsel for the respondent number 4, that they will serve the copy, and but we have not received any copy, and neither any affidavit has been filed.
Who's for 4?
We have filed the affidavit on, my lord, 27/4/2018, my lord.
for respondent number 3 and 4, my lord. And my lord, on that day, my lord, he called me that he has not received the copy, so I was supposed to serve a copy. But my lord, what happened in this case, my lord, we have engaged senior advocate, my lord, S.S. Sharma. After his demise, my lord, we could not trace out the file in his chamber, my lord. Brief, my lord. That is why we cannot, my lord, serve the copy on, my lord, last occasion.
27/4/2018 affidavit, we have on record filed by the respondent number 3 and 4, but it is in the case of contempt case. It was in the earlier proceeding, not in this case. We have one affidavit on record.
There was two cases, my lord, one WPC and one, my lord, contempt case. In both the cases, my lord, we have served the copies, my lord. But and contempt case is disposed of, my lord.
Just a moment, I'm still not understood. You have filed an affidavit in your respondent number
For 3 and 4, my lord.
3 and 4.
3 and 4.
3 and 4, an affidavit has already been filed on
Filed, ma'am.
27/4. Then,
Then, my lord, on last occasion when the matter was, my lord, listed, he paid for furnishing. He paid for furnishing a copy, extra copy, my lord. That copy I was not available since the brief was in the chamber of senior advocate S.N. Sharma, my lord.
okay, so you are referring to the affidavit filed on 27/4/2018.
I have not received a copy of the same.
You've not received, you not take a certified copy.
Yes.
It is a file in 2018. If you want to proceed, you take a certified copy. He does not have the brief. Correct.
Yes.
All sides are duly represented. From the submissions made by the learned counsel for the petitioner and respondent number 3 and 4, it appears that an error has crept in the order dated 10/4/2023, which is which should stand corrected by the order passed today. Next para. It is added in kept in para 2 of the said order. Full stop. It now appears that the submission of the learned counsel for the petitioner was that he had not been served with a copy of the affidavit in opposition filed on 27/4/2018 by respondent numbers 3 and 4. Full stop. Mr. Your name?
JC Google.
JC Gogoi, learned counsel for respondent numbers 3 and 4, has submitted that this case was handled. In this case, he was led by a learned senior counsel who is who has since expired, and that he is unable to trace out his brief for respondent numbers 3 and 4. And accordingly, the learned counsel for respondent numbers 3 and 4 has expressed his inability to provide a copy of the affidavit in opposition filed by respondent numbers 3 and 4 on 27/4/2018. Respondent number 5, who is Mr. Samoy, you are there?
Yes.
You filed your affidavit?
No, I have not filed. I have received the instruction, my lord. I am filing in the next week.
Oh, instructions you received long back before BO.
Yes, my lord, I was sick for quite a long time.
Oh, acha. Okay. Mr. A. Samuel, and standing counsel for respondent number 5. Submits that he was unwell for some time and could not file his affidavit in opposition. In terms of order dated 10/4/2023. He prays for and is further granted how much time?
2 weeks.
2 weeks time to file affidavit in opposition. Having noted that this petition is pending since 2017. The court is inclined to reiterate the order dated 10/4/2023 to the effect that if respondent number 5 does not file the affidavit in opposition within the extended time, the acceptance of such affidavit in opposition shall be subject to further orders may be that can be passed in this matter. Next paragraph. In order to avoid delay in disposal of the matter, in view of the nature of submission made by learned counsel for respondent number 3 and 4, the respondent number 5, the learned counsel for the petitioner should obtain a certificate copy of the affidavit in opposition filed by respondent number 2 on 27/4/2018.
No.
Mr. Gogoi,
My lord,
I think we'll direct you to obtain a certified copy and give it to him.
no, I have already
No.
collected from the UGC, my lord.
No,
Copy is
whatever we-
available.
But no, because you see, what you are doing is not an ethical practice. It has to be deprecated. I'll put it on record, the deprecation, and I'll direct you to take a certificate copy.
My lord.
This is something you should not have done. It is an unethical practice you are doing. I'll deprecate in strongest terms. You don't even address it to the learned counsel for the petitioner, and you have filed it.
My lord,
It's a misconduct.
I could not understand, my lord.
This is not addressed to the learned counsel for the petitioner.
Oh, my lord, that is sorry.
It's a misconduct.
That is sorry.
You should not be let away with a smile.
And I might have, my lord, my.
No,
clerk
not
has-
might have. I don't know. We don't know the clerks.
I will provide him. I have collected a
No,
copy
let me
from
put
the.
down in the order sheet. The depreciation must be recorded.
My lord, my lord. What in the-
It is a certificate copy. It's like okay. It is noted from the record that on 5/4/2018, when, sorry, not that. The 27/4/2018. The affidavit in opposition was filed by respondent number 3 and 4. Full stop. As per record, the notice of service was addressed to the Standing Council for Education and Standing Council for UGC. And the Standing Council for Education as well as UGC had received the service copy on 5/4/2018. Full stop. Therefore, comma, the court is compelled to record that the learned counsel for the respondent numbers 3 and 4 have committed misconduct by not even attempting to serve a copy of the affidavit in opposition to the learned counsel for the petitioner, which is deprecated in strongest terms. Full stop. By not making an attempt to serve affidavit in opposition to the learned counsel for the petitioner, comma, the learned counsel for respondent numbers 3 and 4 have dragged this case for 5 years. First of accordingly, the learned counsel for the respondent numbers 3 and 4 shall obtain a certified copy of this affidavit in opposition within a period of 4 working days from today, and serve a copy thereof to the learned counsel for the petitioner, and also pay a cost of rupees 10,000 to the learned counsel for the petitioner for delay in disposal of this, for causing delay in disposal of this writ petition. Full stop. It is made clear that the cost shall not be recoverable by the counsel for the respondent number 3 and 4 from the respondent numbers 3 and 4. Next para. List on after 3 weeks, 2 weeks, give a date. We'll fix it on that date.
Lordship.
Actually, my lord, my clerk had committed a mistake, my lord.
You
She
will
has
recover from him. Clerks, we don't
I'll
know.
try my best to recover.
No. As a council, you see, you compel me to.
Well,
look
I've
at the-
seen, my lord,
look at
clerk
the
has not
files.
mentioned his name.
You compel me to look at the file. It has been adjourned twice, just for a copy. And when I find that the copy is not served, not even an attempt is made, why shouldn't I do it?
My lord, that is true, my lord.
No, word should go out that the council has a duty towards the, you see, it's why I've said unethical practice is for a reason. You look at the code of ethics for a lawyer. In the book of authored by late B.K. Goswami, you will find that one of the clauses is that you also owe a duty towards the counsel for the other side.
Right.
And that is a part of ethics. So if you don't give a copy and then say that the file is not there, it's not good enough. 5 years you have dragged the matter. Why cost of 10,000 only, 2,000 per year? It should have been a lakh rupees. No, when you should disrespect the counsel for the other side, we should not be lenient. Otherwise, this unethical
I was-
practice will grow. No,
Actually, I was not aware that copy was not served, my lord.
you
Today,
should have gone through it. You should make a submission and therefore I go through the records. I go through
I
the
have not
records
gone
because of
through
my
the court
because
record.
of my background of civil court, where I have been groomed up to look at the record every time.
My lord.
Every time we go to court, as a civil court lawyer, I was required to go through the order sheet, records of the case, what has been filed, what has not been filed. So therefore, that habit remains. And I'll tell you, with all respect to all present, 50% of the lawyers also take a view that I waste my time looking at the records, looking at the Lawazima orders, or looking at the service reports. You may not admit, but 50% of the lawyers whose matters are not taken up at the end of the board. They feel aggrieved because they think that I waste time. And this happens when I look at the records.
They will have
deprecate.
checked the my record, my lord, but I have not
no,
checked that
we
whether
will-
copy was served or not.
No, we won't continue this dialogue because
My lord.
I've done it. And I'm not reducing the cost.
Lordship,
No.
I may be allowed to file my reply.
Okay, reply if any by within 2 days prior to the next date of listing. The date of listing. 17/5.
Obliged, my lord.
Yes,
My lord, in this case, my
Which is
lord,
there.
we filed an IA 1013 for amendment of the prayer portion, my lord. Earlier, we filed another IA 3445. In that, my lord,
interpret the section 1013.
13. my
Oh,
lord.
yes, it is there. It is there, my lord.
So, my lord, earlier implemented the response number 10, but the prayer
Okay.
portion for amending the prayer portion, that was not allowed. And our court has verbally said that if file a separate IA,
Definitely.
my lord. So we have filed the separate IA.
So allow this application. You are for
I am for
10?
private respondent.
You are for respondent number 10.
No, no.
Okay, you are for 10. We allow this application. But we say AR Sigdel and counsel for the applicant. Also heard Mr. S. Bhunyal and standing counsel for the Higher Education Department appearing for the opposite parties. Number 1 to 4. You will appear for Principal West Walpara College also.
Lordship, one.
It is a government college.
1, 2, 3, Lordship.
4 also is a government college. West Walpara College.
Provincialized college. Provincialized college. It cannot be government college.
Provincialized college. So, okay, 1, 2, 3, and 4. And you are, Mr. Azad, appearing for
5, 6, 7,
Governing
7, 8, and
5
6, 7, 8, and 9.
Line is not there.
and Mr. A. Azad,
Okay.
learned counsel appearing for opposite parties number 5 to 8.
6, 6, 9.
6 to
6, 7, 8, and 9.
6, 7, 8, and 9. Okay, 6, 7, 8, and 9. And Mr.
A. Ahmed on behalf of Mr. PJ Kugan.
A. Ahmed, then counsel for respondent number 10. There is no representation from respondent number 5. In a provincialized college, you have a governing body also.
Governing body.
Okay,
Lordship.
next paragraph. This interrogatory application has been filed for amending the prayer made in the writ petition.
Have indicated in paragraph 3
It
and
is-
4 also.
It is submitted that in connection with the connected WBC 539 of 2018, comma, and interrogatory application was filed for including the respondent number 10, which was registered as IA Civil 3445 of 2022, which was allowed by order dated 12/12/2022. We submitted that. The period is liable to be amended as the petitioner is also seeking relief against the respondent number 10. Full stop. Heard the objections raised by the learned counsel for respondent number 10. Full stop. as the respondent number 10 was implemented subsequently, the court is inclined to allow this interlocutory application for amending the prayer made in this in the connected petition. Next paragraph. Accordingly, the learned counsel for the applicant shall file an amended writ petition. And so copies thereof to the learned counsel appearing for the respondents.
Will serve.
Deep please. Right in this writ petition, so in view of the order passed today in WDC, ISC 1013 of 2023. The court is inclined to record that the writ petition is permitted, has been permitted to file a amended writ petition. Full stop. List after.
2 weeks.
Date may be fixed, my lord, because petitioner is
We have to
doing
file
implement.
soft copy.
Okay, give a date after 2 weeks.
19/5.
Deep level.
All right, 19 minutes.
Before.
See, in that change the word, it will not be misconduct, it will be unethical practice. Because if it is misconduct, there has to be a proceeding then. No, in that last order,
Yes, well.
I have changed the word from misconduct to unethical practices, because if I make order the misconduct, then it has to be mandatorily sent to the council. That I am not intending. Wrong practice and not unethical, wrong practice.
18.
My lord, in 18, 19, 20, 21, and 23.
Yes.
We have filed our affidavit today, my lord. There was a little delay. So we have filed the affidavit today.
Lordship, in item 23, we have been served a copy today. Some time to file a reply. Lordship.
Okay.
19th, I also today, I'll with delay. 19, I'm also fine.
You
Item
filed-
number 19, she has also. filed.
Okay. Right, separate orders, huh? This is item number
18.
18. In 18, you have filed, for all sides are represented. Mr. R. Mazumdar, understanding also for the elementary education department, has submitted that and affidavit in opposition has been filed today, right?
Yes, ma'am.
And a copy thereof will be served to Mr. M. Das.
Lordship, on 23, I'll be in 23.
Copy thereof will be served on the current council for the. Dear Mr. S. K. Das is there. You have
We
sent a
have
copy?
submitted, I have personally submitted.
Okay. It's copy being served on the current council to the petitioners. Full stop. Interim order, after this has extended till the next date of listing. List on when? Mr. Das, when do you want?
Lordship, any date, Lordship, Lordship. After 2 weeks, any date, Lordship.
After 2 weeks. No, 18, I give you date after 2 weeks. Anyway, in item number 19, you have filed.
I am also fine, he also fine.
Oh,
both have
19. Also represent Mr. R. Mazumdar and Ms. R. Borobora.
Lordship, can it be 3 weeks, Lordship?
3 weeks, okay. I don't know this.
All right.
3 weeks.
22 fine.
Item 23,
23, I am there, Lordship. 19, I am not there.
it's okay.
Lordship.
In 23, Mr. Also representing on the prayer made by Mr. M. Das and counsel for the petitioner. Matter is adjourned to enabling to file affidavit in reply in the matter. List on affidavit is filed by, in this 23 item, affidavit is filed by.
My lord, the secondary education department. 23 reference.
Okay. Only on the purpose of that.
20 and 21 also I filed. 22, my lord, I would require. There's a mistake on my part, my lord. I sent it to the wrong committee.
21, 2021 you have filed.
Yes, sir.
22 you are seeking time.
22, I am seeking another 10 days time, my lord.
Two. You can just time to resolve the file the affidavit. List of same one. Okay.
Objection.
In 21.
I've recorded your presence.
So I appear in item number 18 and 19.
I've recorded your presence. All sides present, I have said.
Oblige.
Oblige.
Please, your lordship. I think this matter was called in the morning, but perhaps some counsel was not there.
No, he's not there.
It was kept for time being. I'm appearing for the private respondent number 7, my lord, in this case. The previous 2 occasions also, my lord,
He was not
I
appearing.
think the petitioner's advocate was not there.
Okay.
Your loss in.
None appears for the petitioner on call, for the petitioner on call. However, Mr. Borgotaki Leonard, counsel for respondent number
7, my lord.
7. Read serially. Mr. S. Bhuyan and his standing question for
One-
numbers
one
1,
and
2, and
three.
3. We are for
Number 4, your lordship.
your name.
Yeah, I'm like.
Yeah, correspondent number 4 are present. Pushpa. The petitioner was absent on. The petitioner was absent when the matter was previously listed. On 28/1/2019. 16/3/2021. And also today. Even in the second call. So accordingly, it appears that the petitioner is not interested to pursue this matter, and accordingly, this writ stands dismissed for non-prosecution.
Much.
Yes,
May I please, your lordship? Lordship, the
yes,
lordship, the advertisement was for subject teacher in physics, lordship, in High Secondary School. Remove the
Just-
advertisement page number 18.
just. Subject is.
Subject is physics, lordship.
PGT in physics.
Physics, lordship. And the petitioner is having that degree, lordship, but the private respondent who in the meantime has been appointed, lordship,
She is a PGT in electronic science, Lordship.
Okay, MSc in electronic science.
Yes, Lordship. I have annexed the
His
quali-
respondent number?
respondent number
Five, my.
5, Lordship. And this issue has already been decided by this honorable court, Lordship. In 2014 itself, the respondent number 5 approached this honorable court in another regarding another advertisement where this dispute was arisen, Lordship, where it was held that that the subjects are different, Lordship. The subjects are different, Lordship. Page number 29 onwards, the relevant portion at page number 33, Lordship, 32, Lordship. Para 4 may be seen, Lordship. This honorable court already has decided that the
Just now.
both are different subjects, Lordship, and the MSc in electronic science cannot teach physics subjects because it is a wider range in the falls in the wider range, Lordship. Page number 32, para 4.
Yes,
In that case, Lordship, the respondent number 5 challenged the selection of another person who was having the degree of physics, Lordship, and she was not allowed to hold the post, Lordship. That's why she challenged that advertisement and selection that was rejected by this honorable court. Now this time, same type of advertisement, Lordship, PGT in physics. She was appointed, Lordship, and till date she's serving, Lordship. Since there wasn't any stay order.
where is the advertisement?
Advertisement page number 18, Lordship. 25, serial number 25.
Page number
18, Lordship.
18.
Serial
Serial
number
number 25.
Demo, Lordship.
Physics.
Physics, Lordship.
Okay, what is the qualification of this post?
Lordship, MSc Physics, MSc in Physics, Lordship.
MSc.
Lordship. The petitioner having that degree, Lordship, page number,
But you see, in this advertisement,
Lordship.
it says state qualified candidates
Yes,
having MA, MSc, MCom.
Yes,
It doesn't say required subject.
respective subjects, Lordship.
No, I don't know, reading the advertisement.
Lordship. That is why it was subject-wise advertisement, Lordship. Lordship, kindly see the advertisement was subject-wise. And physics is a vast, wider range, Lordship. Electronic science, candidate, electronic science, MA, MSc, Lordship, cannot teach the physics, Lordship. It is a general, and this point has already been
No,
decided.
you appear to be right,
Yes, Lordship, and
but you see, we go by the advertisement,
yes, Lordship.
just like, you see, it's just like a, what you call,
MSc.
a BCom student.
MSc.
No, I'm pointing it to myself, a
Lordship.
BCom student deciding physics and, what you call, computer science, or what you call, what is this? Electronics.
Electronics.
Those things I am deciding.
The subject, the issue has already been decided by this honorable court.
Okay, yes, then Mr. Goswami, short and sweet argument.
My appointment is after this judgment, madam. After this was delivered. And I have filed my pleadings saying that, my lord, basically that to get to electronic science, I have to finish physics. And there is a certificate to that effect from an expert also, that one who has done postgraduate in electronic science is fit enough to teach physics, my.
Physics.
And last, from 2018 onwards, I have been doing that, my lord. But having said that, my lord, it is the authority, my lord, who had appointed me, my lord, at the relevant time.
And there was also an existing subsisting order from this court, my lord, for them to file an affidavit in this respect from them, my lord. I don't think that affidavit has yet come from the authority, my lord. It is appointed.
Yes. What is your stand?
My lord, here my lord, instruction is required, my lord, instruction is, that's true, my lord, some time is required.
Come this side. I can't hear you.
There are many states where, my lord, they have recognized this electronic science as, my lord, physics. I'll come, those documents are there.
My lord, here instruction is not received yet, my lord. So, my lord, some time is required, my lord. Yeah. So kindly accom some time, my lord.
No, you see, 2019 matter
19
is
matter, yes, my
is
lord.
pending only for one matter, one point. Whether a MSc in computer science, it's a computer science, electronic science can teach physics.
Yes.
If you think yes, your director should tell you over phone, yes. That is the only thing you want to do. You can get us in 5 minutes.
Yes, let's see.
Get a call. If the director wants that what you call physics, what you call computer science can teach physics, end of the matter.
Yes.
Yeah. Because when you see in civil service, a man may be MA in history, and he may be heading the Department of Science. Correct.
Yes.
So the director had to just tell whether such person can teach the other subject.
Yes.
Teaching and holding a post is two different concepts.
Yes.
And there's a supplementary question also. Assuming you have a young family member
Yes.
who is about to take admission in a college, would he like to be taught physics by a electronic science graduate?
Core subject.
It's a supplementary question.
Yes.
So whether your director would like to comment in both these questions. If director has a relative, whether he would like his relative to be taught
Yes.
physics.
Physics is a
In
core
this case,
subject.
my
Lord.
lord, my instruction
don't
is
know.
that, in this case, my lord, my instruction is that my students have received letter marks in several exams, in class 10.
No, there is no dispute. There is no dispute. You see, we are not
They have
questioning
done
your
good results,
ability to teach. But the question is whether it can be done.
My lord, yes. My lord, their affidavit is sent.
Students are getting marks for their merit, Lord.
No, we don't know. We will not make a comment. But yes, we'll take it up after some time,
Yes, ma'am.
or we'll take it up on Monday.
Monday
You
is
get
a
a
holiday.
appropriate instruction. Monday is closed.
Holiday. Second, Lord.
Just wait, just wait. No, third. The third is already there in many cases. No, we'll fix it on 8th then,
Eight.
because next week we are tied up. I'm fixing only that query. Your directors has to get a respond to only one. You may
Yes.
not file your affidavit. Miss S. Kangulan, counsel for the petitioner, has referred to the order dated 17/9/2015 passed by this court in WPC 4923 of 2014, wherein the respondent number 5 was the petitioner, and she had approves this court for a so in this set, rate petition, a short question which came up for consideration was whether the expression inverted commas subject teacher in physics from TET qualified candidates having master degree in concerned subject inverted comma closed is MSc inverted commas MSc degree in electronic science or not? Question mark inverted comma closed. And it is submitted that as in connection with the said case, comma, the view taken by the selection committee that the respondent number 5 herein was not qualified for the post of subject teacher in physics on the ground that a MSc in electronic science is not a degree of MSc in physics. Comma. I dismiss the writ petition. This is page 13. And page 32. Red mark. Full stop. It is also submitted that the respondent 5 in this case with a degree of MSc in electronic science was appointed as a postgraduate teacher in physics in Demo Higher Secondary School. Which is challenged by the petitioner. It is noted that although notice of motion was issued by order dated 1/4/2019, but the State Education Department representing respondent numbers 1, 2, and 3 have not filed their affidavit in opposition. The court is inclined to direct the director Mr. U. Sharma and its counsel for the Secondary Education Department to obtain a specific written instructions as to whether the Directorate of Secondary Education Assam permits master degree holder, MSc degree holder in science in the Master of Science in any discipline to be appointed as postgraduate teacher in any science related subject. Keeping in mind taking note of the fact that the respondent number 5 herein is a MSc in computer science. And
Electronics.
has electronic science, and has been selected for appointment as postgraduate teacher for physics. Which should have a vice versa effect, that any degree holder in arts, any postgraduate degree holder in arts, science and commerce stream would then be eligible for being appointed as a lecturer of the postgraduate teacher in any discipline covered by the Department of Arts, Science and Commerce. Next, the learned standing also for the elementary, for the secondary education department shall send a downloaded copy of this order. Whenever the director of secondary education Assam to ensure that appropriate instructions from a competent authority is provided to the Learned Standing Council for responding to the court, specific court query. List on 8/5/2023. Just right, Mr. B.D. Goswami, and the council for respondent 5 is present. Yes, my question
May I
is.
just ask for a slight accommodation on 10th, my
Okay, 10th May.
On 10th.
Mr. Goswami,
Fine.
I have couched my question in 2 ways. Number 1, whether in this case it can be done. Vice versa, in any other 3 streams,
Yes,
whether same is possible or not.
yes, because they started like that MSc, MCom
So
and.
that is why I put that
Yes,
question.
yes.
So then, any graduate from any, what you call specialization, maybe
Yes,
henceforth permitted to take up any stream.
yes, Lordship.
That they have to clarify now.
Yes, that's why. That's
Yes.
why I'm making you understand. My
But I
question,
have got documents to show, my lord, that in other states they have accepted this electronic science for physics, my lord. That I'll
No,
place
don't
by
worry.
an affidavit by
Mr. Goswami,
my lord.
don't worry. Having known you, if I give you 2 hours time, even you can teach rocket science to anyone.
No, it will not be possible for rocket
It will be
science.
possible if I give you 2 hours and give you 1 research paper. I think you will be knowing you.
But
so long.
only one thing, my lord, in this case, my lord, we have tried to show that electronic science is not something, not a subject that is, my lord, unlike physics, my lord. It includes, my lord, physics, and after we get over that, only then can I be taught, my lord, electronic science.
No,
And
no.
there are certificates.
Physics is not a subject in computer science.
Not computer science, electronic science.
Electronic science.
Electronic.
No, physics is not a part of postgraduate.
Not physics is the genus, my lord. Physics is the genus, my lord. The
No, that
electronic
is-
science.
No, you see, I agree. But can I, I'm just trying to understand your example.
My lord.
When I was in a school, I had arithmetic and maths,
Yes,
correct?
my lord.
Then being a graduate of commerce, where accountancy is a subject, can I start teaching maths?
No, my lord, here the petitioner is BSc in physics, MSc in, my lord.
No,
electronics.
you see, I'm telling you with a
Yes, sir.
reason. in my community, I am an outcast, you know why? Mr. Goswami,
My lord,
you know, in my community, why I am an outcast? Because I cannot calculate it in my from my memory and in my fingers, strange calculations. And many of people in my community, you just ask them 100 rupees, 2% interest for 48 days, they'll tell you in
no time,
SGP.
yes, yes.
Correct.
Correct.
Any calculation.
Right.
In our community, earlier times, my father could do it. They knew the multiplications of 1.5, 2.5, 3.5. So by the time I take out my calculator and do the calculation, they would already be out with the answer.
They learned it from practice.
No.
They picked up- they-
What I'm trying to say is that
Yes.
it is because I can't make a calculation so fast as my father could. I am an outcast. They say that you are not from this community. You can't do a multiplication.
But my
You
lord,
need a
if you-
calculator to
my lord,
multiply. and
even
add.
if your lordship takes some more time, but your lordship comes up with the correct answer, it's all right, my lord.
So you see, just because I know arithmetic, just because I have studied accountancy, would not make me eligible to teach maths to a postgraduate student. Merely by saying that I am good in arithmetic.
Well,
can't do it.
they have recognized this electronic science, my lord. The other states, my lord, I have documents, I'll bring on affidavit by the next date, man.
No,
I'll
what
place
if you
this,
do,
man.
but
They have, and here also, she is a graduate, my client, my lord. Graduate in physics, electronic science, possible.
We are talking.
you ask a young mother who has sent her student to kindergarten, and then you will understand the young mothers now. They know the qualification of the teachers who will be teaching
Oh, yes.
students to their kindergarten
Yeah, yeah, yeah.
children.
Yes, ma'am.
In nursery, they want to have the what you call the qualification of the teachers. They will pinpoint. Oh, you are from that school. In that school, that teacher is this degree. He is teaching this class. So I have seen young mothers now who are so
Very concerned.
concerned with their children.
Yes, yes.
I don't think people will like their children to be educated by what you call physics from a
Electronic science.
electronic science. I don't know.
But let
I
it
might
come from
doubts.
them, my lord, then I'll
No,
place
no.
these
This
documents.
is
ma'am.
MSc lordship. This is.
Haryana, Himachal Pradesh and all, they are seeking, my lord, for postgraduate teachers in physics, electronic science.
It's okay. Let us see.
Much obvious. On 10th, my lord. 10th.
Okay. 10th.
25 bail hearing there.
Wait, your lordship.
Yes.
Lordship, earlier your lordship have rejected the petition, your lordship. Earlier there were two petitioners, your lordship, in the order. That your
Show me
lordship,
the last order, then realize.
lordship. Page 28, your lordship, the last rejection order. There were two petitioners there, your lordship.
Oh, this is the Dibrugarh.
Lordship,
matter.
lordship. Lordship, initially in the first FIR, your
You
lordship,
were arrested when?
your lordship, on precisely today is your lordship, on 7/7/2022. Today is 9 months, 21 days, your lordship.
7/7/2022.
Your lordship,
What is the stage of trial?
your lordship, hearing for CC was done in the month of January or February. Thereafter, your lordship, adjournments were taken, and now we have come to know that the additional session judge who was conducting this case, he has been transferred, your lordship.
Where is the last order sheet?
Lordship, I have not annexed here, your lordship.
My lord, last order sheet I have flag mark, but that my lord, scan copy is tag with earlier rejected my lord bail petition. That is tag in the name. My lord, so my lord is much for my lord earlier.
Do not record that order sheet, last order sheets. I would like to go through it.
Maybe your lordship, the
But as
last
far as-
date was on 24th, but no, nothing happened.
Whatever last order sheet is available,
Lordship.
if you, supposing order is passed today, but you don't get a certified copy, omit that. You tell me that there was an order passed on 27, but you did not get a copy. Just indicate to me that.
Lordship.
I wanted to look at the order sheet of the trial, the stage of trial.
Lordship. And your lordship, my humble submission in this case is your lordship. There were originally there were three accused in the FIR. Subsequently, two more accused were added and searches were given against 5 accused, your lordship. One of the 5 accused, your lordship, who was an absconder, after interference of this honorable court, your lordship, he got bail from the Dibrugarh additional session bench. And the FIR as well as such seated accused, your lordship, Nissan Sharma, who is one of the prime accused, he was granted bail by a coordinate bench of this honorable court, your lordship. So, your lordship, I am before this, and your lordship, since this petitioner, your lordship, he was not at all associated with the business because it all.
That is okay. You just bring the copy of the order. We'll consider your application.
Lordship.
By when you will produce that?
Lordship, I need 6-7 days. Your lordship.
There's a calendar. You just take a date. We'll fix it on that. Take any day on Monday, Tuesday, Monday, Wednesday, and Friday. Any day you want.
Can it be on 8, your lordship?
Yes, we'll take it.
My lord,
Because the trial is not proceeding, we can't insert a person for long.
Lordship.
294 days till now, my lord.
No, but.
Yes, yes, last order-
Then I would have understood.
Last order is.
But if the trial is not beginning, then possibly. The court is inclined to ask Sai Hussain, learned counsel for the petitioner, to produce a copy of the copy of the last 2 or 3 orders of the trial court from which the stage of trial could be understood. In this regard, the learned counsel for the petitioner submitted that as per his instructions, although the hearing on charge framing was held, but the then presiding officer is now under transfer. And therefore, as per his instructions, the charges has not been framed. So be that as it may. Now you're right. This is director for this list on 8/5/2023. Mr. K.K. Parashar Lana, APP is present.
40 seats.
46 वाला सीधी available. This is also earlier rejected by lordship. Page 25 is the last order. Earlier rejection.
Page 25.
Page 25.
What is the stage of investigation now?
Investigation is still going on, my lord, not yet succeeded. But this petitioner is not cooperating, my lord. I always said that this Munna Soikia, my lord, 41 a notice also given to him, my lord. He has not appeared, my lord. And my lord, he is not cooperated because my lord earlier also is transportation of cow with my lord, fake challan, my lord, from different states to Assam.
Now the person call for the petitioner. Mr. K. Parashar and the APP is present now with the case diary. You have the case diary?
Yes, my lord. Sri,
Supervisor, this matter stands adjourned today. That's why the learned APT is permitted to retain relevant pages of the case diary, photocopy of the relevant pages of the case diary and return the case diary to facilitate early investigation.
my lord.
List on. After 10 days, give a date. 17/5.
17.
No, make it 10. 7. For bail 72.
My lord.
10/5.
10th.
You send back the case diary.
My lord, my lord.
Just wait for 5-10 minutes. Maybe the council is not aware that I am taking up out of turn. Item 46. Just wait for 5 minutes.
26 for orders.
Yes, Mr. Agarwal.
Yeah, my lord, though the respondents have informed this honorable court that the order has been complied with, but my lord, I am unable to obtain instruction from my client. So some more time may be given to me, my lord. But I have come to know that this petitioner has died, my lord.
Yes, okay. Can you give a copy to him? Mr. Mazumdar,
My lord,
he's Sagarwal says that the petitioner might have died. Living well. Can you give him a copy so that we can follow it up?
Yes, one copy has been given to me on the
Copy has
last
been given.
case. my lord.
Oh, okay, okay, okay. Both say they will be present.
It will be here.
Rather than transfer the petition.
order to case. You
He submitted that although he has received a copy of communication that the order of this court has been complied with, but he is unable to make a contact with the petitioner to have his instructions.
In fact, it's a question, it's a company important.
First one.
I made this point of wonder, I have an instruction from the Director of Elementary Education saying that the pension payment order in respect of the petitioner Bholanath Sharma, expired assistant teacher by the Director of Pension has been granted, madam.
No, he is saying that he received your instructions,
Yes,
but according to him, the petitioner might have died.
yes. The petitioner kune Bholanath hai? Oh, the wife of the pensioner has also expired.
So,
No, the petitioner has expired. He has expired, man. That is on record.
okay.
He has expired. With
No.
reference to the subject cited above, I would like to enclose here with a copy of the pension payment order in respect of the petitioner Bholanath Sharma, expired assistant teacher.
Okay. So then we close it. That has been made.
And the payment has been arranged for the wife of the
Just
expired teacher.
give me the copy.
That I have got. Huh? That I have.
Taking the program. Renu Sharma দিয়েছে। My wife is giving it.
Pension paid.
Page 2, the second page is the forwarding and the third page is the.
See, after so many years, the 2015 matter, 8 years, we may not be getting instructions. And rightly so. This PPO is issued on 6/4/2023. He will not get it, that information, sir. Agarwal will not have it.
It has been arranged for his wife now, all these payments to be made.
This is the pension amount,
Yes, ma'am.
this pension amount.
With arrears, my lord, it has been given, it was. If I'm not wrong, the arrear pension that the expired teacher would have received and the family pension.
No, because this amount says 21,980.
So my lord, this is the amount which the petitioner will get, but he will possibly get for right from the date of retirement. The huge amount will be this. 77 Yes. Petitioner retired in the year 1977. So from that year, it will.
No, then I think I should, instead of closing it, I should defer it.
My lord,
I should defer it. If you are saying if you're saying that the petitioner, had superannuated in 77.
yes.
This Renu Devi's wife will be alive or not, that also we don't know.
Well, yesterday, while I was having a talk with one of the officials, according to him, she is there. And after having sort of calculations and all these, the relevant order has already been transferred to the concerned department in Kardiala to do the needful immediately. So that's the thing.
No, this 77 years he has expired.
77 retired.
No, he is retired. 77 and now would be about 46 years.
Well,
He retired in the year 1997, my lord. In the year 1997. he retired.
97.
97.
1997, okay, let us say 97. 97 would make it,
strongly retired.
no, it's okay. 97 if he is retired would be now 26 years.
Yes,
26 years.
huge amount.
So no, I'm not on the amount. I'm on the age. The lady, whether she will be alive or not.
Wife could be younger, my lord.
She's
She
alive.
was 60 at that point of time. Wife could be younger. Anyway, my lord, this speculations apart, if lordship, he may have an opportunity of finding out, my lord, because he also has a pension payment order in favor of the wife. With the effect from 97, she would get around 17 rupees. From 2007, she would be getting 2,700 rupees as pension. These amounts are given, so everything will come up as an arrear.
Both sides are represented. The Mr. R. Mazumdar and Mr. Kanivas for the Secretary Education Department has the Elementary Education Department has produced a copy of Instructions by letter dated 6/4/2023 by the Director of Elementary Education Assam. Enclosing therewith a photocopy of order bearing number capital ADP oblique PPO oblique GPO oblique 2023-24 oblique 087340 dated 6/4/2023 bearing GPO number ADP oblique PPO oblique GPO oblique 2023 oblique 087340. Whereby a sum of rupees 21,980 is ordered for payment from Golaghat Treasury to Renu Devi, wife of late Bholanath Sharma. Mr. Mazumdar, I am not good in reading these papers. But this only reflects death cum retirement gratuity of 21,000.
The pension part is with him, my lord. He has that piece of paper which is granting her pension.
Also enclosed therewith is the pension payment order in respect of the family pension at the rate of rupees 617 WEF with effect from 1/4/1997 up to 39/2007 and rupees 2770 with effect from 1/10/2007 to 31/3/2016 and at the rate of rupees 6870 with effect from 1/4/2016 to 31/3/2021 and rupees 5500 with effect from 1/4/2021 onwards, which is issued by the Finance and Accounts Officer from a Directorate of Pension from Assam. Full stop. Which is in comma, which is in favor of Renu Devi, wife of late Bholanath Sharma. Full stop. That's correct. Mr. M. Agarwal, the counsel for the petitioner is present. Have you noted that the petitioner has expired? The petitioner, namely Bholanath Sharma, has expired. And that the pension payment order in respect of family pension, as well as death cum retirement gratuity, having been issued by the Finance and Accounts Officer, Directorate of Pension Assam. The court is inclined to close this contempt petition. Because though belatedly, the order is code dated 2/6/2014, passed in WPC 3074 of 2013 has been complied with. Next paragraph. The learned standing counsel for the learned counsel for the respondents shall provide a photocopy of the pension payment order in respect of family pension and death cum retirement gratuity to the learned counsel for the petitioner. We're closing it because now since they died, unless it is substituted, can't proceed. So this pension payment orders, you take after some time. Let me secretary cross check. It is about the number. In the left side, there is one number. In the right side, there is one number. 2022-23. In the right side, the 23 is not there. 24 is not there. 2023, 24. 24 is not there in the second number. Contempt is closed because the petition has expired. But let my secretary cross check and write that pension payment order. If there is an error, he will again not get the benefit.
27.
I went, I'm for respondent number 1.
Okay. Respondent number 1, and you are for?
Okay. My name perhaps does not appear there. I'm only given the instructions to please. This name would do, madam. This is not difficult.
Okay.
I'm for 4.
Mr. S.P. Bhattacharya, respondent number 1. Yes. S. Kemprai, counsel for respondent number
4.
4.
Yes, sir.
2 also then.
Yes, Lord. It will also be able
If you're for 2 also.
You see this.
Subject court. Well, to my knowledge, the J. Abidin was representing. Possibly. Yes, ma'am.
I know.
Possibly he is there, J. Abidin, but he is not there.
For 2.
For 2 most of them.
Okay. GRB for respondent number 2. Okay.
Copy of that GPU I have given to your
You
lordship.
take it after some time. Let my
lord.
secretary cross check it. Just wait for some time. You cross check it and you can get it from the court master. Once he rises, we'll check it and then he'll release it. You just wait for 10-15 minutes. When he rises, we'll give it to you.
My lord, item 46, my lord, petitioner advocate, my lord, that bail matter, my lord, petitioner advocate out of Guwahati, my lord, the junior is present, my lord. Already fixed on, my lord, 10th of May, my lord.
Okay. Okay.
He is out of, my lord. Guwahati.
27.
27 lawsuits were completed in 2017. Petitioner received a relief engagement among lawsuits.
Oh.
2017.
Yes, my lord, you are aware of it.
My lord, as per the earlier order, my lord, respondent number 2 was supposed to obtain instruction regarding the compliance with the report.
You see, in 2017, it has been completed.
2017.
My lord, we have no communication with the petitioner. My lord.
His token number is also there, lordship. Everything is there, lordship.
Date of payment is 5/9/2017.
Lordship.
So you're closing this content, we will record this. Mr.
D. Raj, my lord.
B.
Das.
Raj.
Das. D.
Das, okay. Learned counsel for the petitioner. Mr. K. Gogoi, learned counsel for the respondent number 1. Has produced a copy of instructions dated, written instructions dated 27/3/2023. By which the learned counsel has been informed that a sum of rupees 45,814 was sanctioned by the Accountant General Assam in connection with leave encashment claim of the petitioner. And that the bill of the leave encashment has been passed by the DIFU Treasury DIFU on 5/9/2017 under bill number 35 dated 11/8/2017, token number 2017/08/1994 dated 29/8/2017, the date of payment being 5/9/2017 under T full stop V full stop number token voucher TV number 2071/79 dated 5/9/2017. Full stop. Accordingly, it appears that the order dated 29/10/2013 passed by this court in WBC 6373 of 2006 has been complied with. But Mr. Gogoi,
Lordship.
is something wrong in the calculation?
Lordship.
The petitioner was, he retired as professor of political science,
Lordship.
correct?
Lordship. Lordship.
As per the judgment of this court,
Lordship.
he was entitled to 300 days of leave encashment,
By Lordship.
but he received the benefit for 80 days.
80 days already given, Lordship.
No, it's okay.
Lordship.
So this is 220 days.
Lordship. After deducting 80 days, Lordship, the authority has.
No,
Yes.
I understand. I'm not on that. So for 220 days,
Lordship.
will the salary of a what you call
Lordship, this is
professor
Probably this is for 114 days after, as he has calculated lordship, his unleave is total 114 lordship plus 80 lordship. Other documents lordship.
No, this High Court gave a finding
Lordship.
that his leave encashment is 300 days,
Lordship.
less 80 days. So it is 220 days. So will the salary, this leave encashment
Lordship,
for 220 days?
before 2001 lordship, salary is less lordship. Before 2000, the UGC scale of pay lordship, the UGC scale of pay lordship, it's from 2002 lordship, it's start lordship. Before that lordship, the salary is 7,000 or 9,000,
Scale of 7,000 to 9,000.
9,000 lordship. Since 2010 lordship, it's lordship from 52,000 starting lordship. Now it's as a professional lordship, it's up to 2 lakhs lordship. Now they are getting lordship.
No, that's why I was
Lordship.
calculating.
Lordship now to more than 2 lakhs lordship. At that time, lordship 7,000 to 9,000 lordship.
That's why I said,
Lordship.
yeah, I said just now
Lordship.
that people question my ability because I can't calculate very fast.
Lordship. At present, more than 2 lakhs lordship at present lordship.
Okay.
Oblige lordship.
According to this contemplation stands closed.
I am appearing for the respondent three.
Your name?
SK Dekha.
SK Dekha for respondent 3.
Oblige lordship.
28.
My lord, in several occasions they taken time for file rejoinder, my lord. Maybe it given, but maybe a last chance, my lord.
Reply lordship. 1 week time maybe allowed to file it.
One affidavit file.
Last chance. Mr.
My
Goswami says
lord,
last chance.
let the matter be end, my lord, for 15. Government is secondary education council board of secondary education council physically report nasil
Okay. It appears that
in
Mr.
the
Goswami
event of
has
their filing, I will file reason affidavit.
it appears that Mr. Goswami has a strong case. That's why he's insisting on a early hearing. Okay.
My lord, his post is not provincialized. That is 2011 acts under this act, my lord, that will be go to the tribunal. As per that, all the act is already repealed.
That is why you are all smiling.
My lord, let them file, my lord. I will file reply, my lord.
As a last chance, 1 week's time is granted to the petitioner to file affidavit in reply, so advised. Reply if any. No, but you can't give a reply to reply.
My lord, if the affidavit file, my lord, I will file reply.
No, but reply to reply, that would be endless.
My lord, another last rejoinder is file the rejoinder, my lord.
No, I understand. Rejoinder is permissible, but reply to a rejoinder, that is not permissible.
Court may be if additional affidavit,
No,
additional WS is filed, my lord. Additional plaint is filed, my lord. The additional WS is allowed.
No, that is
Because
okay.
they
but
are
this-
amount
no,
to
no, no.
plaint rejoinder means.
You don't say like that.
My lord.
You see, if it is an amended, then I understand.
New
But-
facts is come, my
But
lord.
this is a reply which is within the meaning of what you call additional pleading within the meaning of order 8 to 9.
My lord. If it's nothing new, my lord.
No,
that's-
whatever be, but no reply. Otherwise, you will not be able to hear it.
Otherwise, I have already filed, my lord. It will cover. If
But
new
activity
point.
is- what's your advice? No further adjournment will be given for that purpose.
Yes.
This is the matter on.
Yeah, good.
Your date after
Yeah,
10 days.
No, no, I'm looking at note.
12/5.
Repeatation.
12/5.
No. Repeatation. 11.
In this case, Lordship, can fix a date for admission. Earlier, there were 4 respondents. 4th respondent's name has been struck off, Lordship. Steps could not be taken because we could not verify the name of the father's name of the respondent number 4. And thereafter, the respondent number 4's name was struck off. Now, as far as
The
respondent number-
Ganguly Learned Council for the petitioner submits that as the names of respondent numbers 3 and 4 have been struck
no,
off.
no, only 4.
Once on the respondent 4 has been struck off. The case is ready for being listed in the admission column. Accordingly, this is matter after a week in the admission column.
Let it be after 2 weeks. I need to take instruction whether Lordship
Okay, 2
matter
weeks.
may have become infructuous. Also.
Okay. 2 weeks. Yes, elementary education.
Wait, please.
This matter was heard by your Lordship on 10/4, my lord.
I have seen that.
My lord.
Yes.
But here,
Any possibility of saving this review petition?
Madam.
Any possibility of saving this review petition?
difficult to be fair. Well, the only thing, well, which probably, well, in my understanding, now pursuant to the report of the screening committee, those opposite parties, well, in the petitioners, those who have already been accommodated as a tutor, and they have accepted that appointment order, foregoing the past service benefit, including the salary. Well, probably that could be an estoppel for to claim the benefit under the, because pursuant to the decision of the cabinet decision and the screening committee's report, most of the opposite parties, they have been appointed as a tutor.
No, you see, Mr. Kaushik.
Hello.
For even for that purpose,
Hello.
you'll have to demonstrate that the review is permissible.
Hello.
Because so far as I understand, subject to how you argue,
Hello.
the scope and ambit of review petition
Very limited.
is only 3. Number 1,
Yes.
there should be error apparent on the face of record.
Absolutely.
Number 2, that that despite due diligence, something could not be brought to the record of the court. And third is for any other reason. Any other reason has been interpreted not only by the Supreme Court, but also followed by this court.
By this court.
By saying that any other cause should be in consonance with A and B.
Correct.
Principle of adjudicem generis has been invited. Or if otherwise it leads to an injustice. In one of the decisions, it is that if the order of the court leads to an injustice, then that will also be covered by the third cause, that is any other substantial cause. So the question is whether that aspect of the matter, even if relevant, can be examined in exercise of review jurisdiction. That is number 1. In other words, scope and ambit of review jurisdiction. The second point which Mr. Saikia has raised on the last occasion is that the directions in the writ petition was against 5 respondents. 3 respondents are the petitioners in the review petition, and 2 others have not been impeded. Therefore, the order of the court has been accepted by 2 of your authorities. So whether the review would be maintainable by 3 out of 5 petitioners, that is one part. Second part is that common order was passed in 3 writ petitions. This review is preferred against only 1. So in respect of the other 2 writ petitions, the state has accepted the judgment. Therefore, there is hardly any scope. That is the second leg of the second argument. So in both these parameters, whether the review petition can be adjudicated, that is the issue you'll have to argue.
Madam. But in that case, I'll seek an accommodation because these 2 parameters, if it was argued, it was not made to my knowledge, because Mr. Khataniar was there in the earlier occasion.
Yes. Because in this,
If your lordship takes up on Tuesday, I'll answer to that one.
no. You see, adjournment will not help it because in both these parameters, the legal answer to it has already penned down. It is no.
And just try to,
Because once you see the authorities, out of 5 respondents, 2 have accepted it, and they are your own authorities. So in a department, if 2 people accept it, then the endeavor of the state fails.
But the other
Because you
two,
see, the government must speak in one language. So if you permit 3 of them to challenge instead of 5, that may not amount to speaking by the government in one language.
in my humble submission, I'll answer that. The state and the director, the other 2 authorities do not have the capacity to comply with that order. Because it is otherwise the director and the state which will have to take a decision on the direction which has been passed by the compliance is upon the director and the state, the commissioner and secretary. The other 2 authorities.
No, then even that argument would fail, because then you would have implemented the other 2 parties as perform respondents. That you don't do. You conveniently keep those 2 people out, which amounts to what you call acceptance of the judgment by 2 out of 5. So even if you rectify it, let us say you amend this petition tomorrow, you impeach them, bring them on record. But still this, the other category which, the other aspect which Mr. Saike has argued, to the fact that there was a common judgment, but the reviews is only against 1. Then that also you can't remedy now.
Yes.
Because although we are not taking up that issue, but you see, even for review, there is a division bench judgment of this court which says that for a review, articles of limitation would apply. So even if you now try to say, remedy this by filing two other review applications. Still, it will be horribly delayed. It's a 2016 order.
Yes.
16 and now we are 23. Would be how many years?
7 years.
7 years.
Despite
Because you
their
see what is happening, Mr. Kaushik. Merely because of this adjournment, the orders of this court is not being complied with.
so that I understand.
And
I'm
this,
just checking, if
and
you-
this is something which is affecting the petitioner's right very, what do you call it, is cutting them deep. So I think by dismissing this, it will give a right to appeal. Maybe you'll be in a better footing there. Because review can't be maintainable. I've tried to examine. But you see,
committee-
examining singly without any assistance of anyone doesn't, is not very happy situation.
True. On
Petitioners have been waiting for more than 6 years for their rights. 7 years.
7
We
years.
can't possibly delay it. I think you'll have to permit me to close this review petition. Because on both the grounds, it's just not possible. I've tried every part, what you call, to examine it, to save it, but you see the review petition. If I just show you that review petition. Come to page 22.
Please, can you come in?
Now. This. The petition was disposed of by order dated 16/6/2016,
Madam,
right?
yes,
Now you say. In ground A,
madam.
you are saying that. The jurisdictional screening committee had submitted its report with regard to validity of the appointments of the petitioners to the government, which had recommended that the petitioners were not appointed with following due process of law. This fact could not be placed before the court at the time of final hearing of the matter. Now this, what do you call this exercise, was done when?
But the committee which was constituted was on 3rd of November 2016.
3rd of November 2016.
16.
Correct. So therefore,
Earlier, the committee was notified on 4th.
no, that is okay.
Yes, but by that time, it was
So
reconsidered.
therefore, 2016, this case was disposed of.
Disposed of.
So a committee which came into existence later in point
Later
of time. That is not a case where you could not place it. It was never existed on that day. See, in a review petition, is it permissible for the court to take into consideration a document which was not available before the writ court and then adjudicate? So even if we come out of these two queries I am proposing to you, even here I find that there's no way to sustain it. Because this is something which, if I'm permitted to say, it will be just like a may not be appropriate, I think. But still, something equivalent is a decree which is not compliable. It's a non-executable decree. Now, if you have found out that these petitioners were not working, they were illegally appointed in not provincialized, whatever your allegations are, it would definitely be you will have other avenues, but can that be taken into account in a review? I don't find that any answer is there.
But yes, but the basic ground of review in this repetition is only that.
No, but that you see, that would be reopening and re-hearing on merit. And if something is disposed of today, something subsequent event which will happen tomorrow, can it be a ground of review? I have not found any decision to that effect. Because your grounds are based on these subsequent events.
No.
Subsequent event is not a ground to disturb anything by review.
But the 2016 notification, it is a reconstitution of the committee which was already existed by virtue of the notification of 2014. If your lordship allow
No,
me,
you see,
page 77.
no. You see, you may have a good case. I'm not saying you don't have a good case, but is it a good case for a purpose of review?
No.
Because if you have that screening committee, those things are there, perhaps you have other avenues available to you. That's why I said, once I dismiss it, then you will have a good ground of appeal. He was a very celebrated lawyer who always used to say, when he loses a case, he would tell the clients that
Right of
you have acquired a right of appeal, which the other side has
lost it.
lost. So, yes, Mr. Sakya, you concede to his prayer.
One more aspect, my lord. There is a specific finding by this honorable court that the petitioners were selected, and after selection they were appointed. And the screening committee says they were not selected. That findings of the selection, screening committee cannot.
Where is that? Where is that?
Let me find the order. Page 43, my lord.
Page 43.
My lord, paragraph 12.
Just a moment. I only marked this word fate accompli, but where is that finding? Constituted statement prepared the state vindicates the stand of the petitioners. In fact, the petitioner granted salary, regular skill appointment is not disputed.
Paragraph 13, my lord.
13. And several of the advertisements to the finding. No, you see, this I'll not make any comment at this moment. You see, the very reason is there is no categorical finding that has been done. This observation has been arrived with. I marked this part. You see, this observation is arrived at on the basis of a presumption that since you did not proceed with them departmentally, that means that it was in accordance with law. That is a presumption. And presumptions, Mr. Sakya, is always debatable.
Yes, but that is true, my lord. But one more thing, my lord. The selection list was produced before this honorable court. This is still, my lord, the part of the affidavit in opposition filed by the respondents. The consolidated statement prepared by the authority, my lord, that was is also part of the report, my lord. My lord, considering this select list and the consolidated statement,
Mr. Sekia, you see, I always oscillate. Once I'm here, tomorrow I may be there.
my lord,
I always oscillate. But you see, you are entering into the merit. If I open into the merit, then why should I not hear the writ petition as well? Because now we are on the maintainability, on
My
the
lord.
grounds of that. But if I enter into the merit, then perhaps I'll have to examine the entirety of it. Then we don't know what happens when. Correct.
my lord.
So merit, I'm not examining it right now, though I have
Right.
read it, the parts of it, but merit, I'm not going into it right now. So,
Otherwise, the reason for granting the relief was applying the principles of quantum of merit. Malad, applying the principle of quantum merit, the direction was given by the Honorable Court. Madam. It is not that the categorical finding was given that they were selected by person to a
you
selection.
see, principle of quantum merit is what? If somebody is rendered service and therefore.
And therefore, they
Once they
Yes.
alter their position and give their service, they are entitled to the payment. From your review, I don't think there are any cases made out that they have not rendered service.
Malad, in para 19, Malad, may I read it, Malad?
No, not the statement.
Malad.
You see, in order to sustain that they have not worked, you'll have to produce something more before the court. Because you are in review, you'll have to prima facie demonstrate without making me read so much. You must prima facie satisfy the court that these people were not working. And therefore, quantum merit could not have been examined. Quantum merit, you will find there is also Supreme Court judgment on quantum merit. Let me elaborately explain what is quantum merit. It's something akin to section 73 of the Contract Act. I think I'll dismiss it. I'll give my orders because at 4:30 I have a meeting with just right, Mr. B. Kaushik for the petitioner. I, H. Saikya for respondent. It will be released only on Monday. Today I'll not have time. The meeting is. Quantum will.
It will be listed.
Quantum will be listed separately. Quantum. Because the disposal of the connected review petition for this contempt petition shall be listed after 3 weeks. Instead of 3, we make it 4 weeks. We will give them time to appeal.
In the meantime, Malad, I will also have to file Malad imaging petition because all the officers have been transferred, Malad.
Okay, but we'll make it 4 weeks. Let him
Malad.
get some time to do what I have suggested.
I do.
না হওয়া না